May I please, Your Lordship? Lordship, I beg to mention for listing of a bail application, regular bail application. On 20, Your Lordship.
May I please? May I please, Your Lordship? With the consent of other side, I beg to mention item number 22, Lord. Lordship, during the pendency of this bail application, the Government of India has issued detention order against the petitioner, Lordship, and we have challenged it, and that petition has been allowed, Lordship, and we are yet to have the copy of the certified copy of the order. So matter may be taken up after vacation.
The against the detention order you have challenged, so that order has already been passed.
That matter has been reserved already, judgment issued. So after vacation.
Okay.
On the last occasion, my name has been wrongly recorded, Lordship.
Okay, that's it. Please, that's it. No, you check. Okay. After vacation?
After vacation.
Do you want to be fixed? Do you want any fixed after
No.
Not to. Okay, we'll see. We'll make correct.
Will inform the court.
Okay.
Obliged.
May I please, Lordship? Lordship, I beg to mention bail application number 571224 for listing 28-6.
Now see, today also as your request, we made several things, listed at the bail application. But today also I am writing like interviews are going on. So if it is big also, I will why don't you put it in the vacation board on first and second and third board, every 11 and 12. Make a mention over here because second 28 also I'm having a meeting. I don't know. Whether most probably first or second or third vacancy for vacancy.
Obliged, okay.
May I please, Your Lordship? I beg to mention item number 31, my lord. I appeared on behalf of Mr. S.H. Chaman, my lord. He is the conducting counsel and he has some difficulties today. May I beg for adjournment of the matter, my lord? It's a bail application and perhaps it is also available, my lord. He has some difficulties and the case is also with him, my lord.
It was the bail hearing matter.
Yes, my lord. After vacation,
so
my lord.
After vacation?
Vacation, my lord.
He did not visit.
Not visit?
He said he did.
Perhaps
31.
31. No.
Not this.
After vacation, in that matter.
After vacation. In this, no?
After vacation, I need to pick the
That's it, no?
26.
Hello, okay.
Is this charted one? No.
No. Hello.
27?
No.
May I please,
Your Lordship? Lordship, I beg to pray for listing of a matter, my lord. One IA, my lord, along with criminal appeal. In the IA, we have preferred, my lord, that the person is on previous bail, my lord. So only that the period will be over by 10th of July, my lord. So only the prayer for IA tomorrow, my lord, for extension of the bail. Small matter, my lord, tomorrow. We'll take a chance. Only the IA. I'm deeply appreciative.
May I please, Your Lordship? Your Lordship, beg to mention item number 41 and 42, Your Lordship. Your Lordship, in both the matters, Your Lordship, we are going to file one additional affidavit to bring some documents on record, Your Lordship. And those documents are very much necessary for the adjudication of the matter, Your Lordship. After vacation, Your Lordship.
Otherwise, we have received case that
It is here, ma'am.
After immediately after.
Also, he was retained.
why are you on interim?
Yes, Your Lordship. Some documents are there, Your Lordship. We need to file, bring those documents on record, Your Lordship.
Metro will be listed on 29.
Interim may be. highly obliged, Lordship.
And mileage schedule return to manner and up to date.
Yes, up to
Lordship, I beg to mention item number 30, Lordship. I am appearing on behalf of M. Hussain, Lordship. Perhaps, Lordship, scan copy not received, Lordship. Scan copy was called for. As per cause list.
call for.
Yes, as per,
One office note is there. But,
yes, sir. But scan copy not. Can it be, Lordship, after vacation, any date?
Second piece. Can go. Can go. After picking, you want any fixed it or it will be after
Fixed it.
Fixed. Fixed zero will
Short, too short. Some short date.
want to short it.
No.
26 then.
May I please, Lordship. Lordship, I beg to mention for listing. The motion matter, my lord. Petition is the jail, my lord. So matter will be listed tomorrow, my lord.
What kind of
Pokso, my lord.
the bail application?
Bail application, motion matter. Obvious.
Lordship, I'm paying for listing of a BA, my lord, on day after tomorrow, my lord. Regular bail application, my lord. He is in jail, my lord. Lordship. Day after tomorrow, 28.
On the motion call.
Only motion, my lord. Motion.
May I please, Lordship? I beg to mention a listing of anticipated bail application for motion on tomorrow, Lordship.
Yeah.
Lordship, petitioner is a lady who is having a
But if there could be after 28.
20 obliged.
Please, Lordship. Lordship, I beg to mention for the listing of a bail application, Lordship. It will be coming up in the motions column. Can it be taken up tomorrow, Lordship?
Or I can take
Day after tomorrow?
the day after.
Day after tomorrow? Obliged.
Record.
May it please, Your Lordship, I beg to mention item number 46 for withdrawal.
Yes, it is for withdrawal only. Why you made? Already there.
So maybe withdrawn.
Yes. Repeat.
May I please, Your Lordship? I beg to mention the withdrawal of item number 50 of the supplementary list.
50.
50.
Otherwise, healthcare can come.
Scan copy received, but Lordship, the evidence of the victim has already been recorded by the trial court. So the clients are interested to apply for a bail because there is nothing in the evidence.
Okay.
Obliged.
May it please, Your Lordship. Lordship, for listing them in motion column of tomorrow, in the accused person behind over for 56 days. And similar in another cases, the accused person was been granted bail by the Honorable Court, Lordship. For tomorrow motion column.
Tomorrow, I don't know. I need more. You can pay for the ticket code also on that.
Yes, Lordship.
Because lots of matters have been listed for motion only. I don't know whether it, today also most of the people will be left out.
In Lordship, day after tomorrow, Lordship. 28th.
May I please, Lordship, I pray for listing of a criminal petition, my lord. Day after tomorrow.
Mention before the senior bench, court number 21.
May I please, Your Lordship? Pray for listing of a AB, Your Lordship, 128, Your Lordship. Motion column, Your Lordship.
It's it before vacation bench on second.
128, Your Lordship. Motion column, Your Lordship.
AB also AB.
AB.
May I please, Your Lordship? Lordship, prayer for listing of a WP criminal. NCB has filed their affidavit. The accused is behind bar for 11 months. Lordship, kindly 120 admission call.
Admission? Possible, not at all. Not at all.
May I please, Your Lordship?
Vacation bench for vacation.
May I please, Your Lordship? Lordship, I beg to mention item number 36 of the daily list, Lordship. Lordship, madam will be listed after vacation. I am on interim.
We have received receipt
Madam, here excise department, madam, SC excise.
side. We do have any information with us regarding receipt of any case that no.
If receipt may be retained, Your Lordship. Immediately after meeting.
Okay, just wait.
Yes, sir.
13.6. Wait. It. After we keep it, I don't know what.
Interim may be.
31.7. Interim was there.
Yes, sir.
Interim.
Obliged.
May it please your Lordship. Lordship, I beg to mention item number 21. Lordship, kindly pass over for the day.
21.
21.
Here we have received it can copy.
Yes, sir. Lordship, it can be come after vacation, Lordship. Can it be on 18/7, Lordship? Obliged, Lordship.
Next, please, your Lordship. Lordship, I beg to mention item number 24. Can it be taken up after vacation, my Lord?
24. Yes. 31.7 will talk or dot?
21/7.
No, 31.
My Lord,
31.7.
31/7 will be can it be, my Lord, or not? 25 or 25 would be 25.
Oh,
Deeply obliged.
May I please, Your Lordship? I beg to mention for listing a bill with Your Lordship day after tomorrow, Lordship.
What kind of AP or
B, Your Lordship. Obliged.
Clear, Lordship.
you are Mr.
BLESK.
Yeah. Want to withdraw?
Yes, sir.
For instructions of the client. Should be disposed.
Obliged.
My Lord, in this case, the petitioner was arrested on 28th of May in connection with this case on the basis of a statement of one co-accused and without being anything recovered from his possession, along with some other person who is also petitioner before Your Lordship in item number 4. So, my Lord, what happened in this case, my Lord, on 24th of June, prime accused was granted bail. There are 3 accused persons. So, it remains 2 persons. Nothing has been recovered from me and other person. So kindly this matter may be taken up on 2nd or 3rd of vacation bench by calling CT.
Not fix it directly in the vacation. We have to make a mention. Put there.
My Lord?
We are not fixing it before the vacation bench. Have to mention. Otherwise, we may call for a case diary.
Yeah.
Because your petitioner is in jail since 28/5.
28/5.
28/5. So it's a key. It's a intermediate quantity.
Intermediate. So if it is not fixed and during vacation it is unexpected to for listing.
Is there any procedure? Not the procedure, you have to make a mention most probably before the vacation back. Do one thing. We're fixing it for case diary immediately after vacation. You make a mention.
No, my lord. Then I have instruction to withdraw this.
You want to withdraw it?
With liberty to file if required. I will try in the court below then.
No. Why don't you appear before the vacation? Make a mention before the.
It is not possible. There are a bunch of matters and urgent matters. If your lordship would fix, and earlier there are instances that regular benches has fixed the matters in vacation bench. There are so many instances.
You want to withdraw it?
Yes, if your lordship unable to fix it, then I have to withdraw item number 1 and 4.
1 and both 1 and 4.
1 and 4.
Same date of arrest is 25.
Same case.
No, I'm just asking you that we can fix it for CD just immediately after vacation, and you can
No,
make
it's
a
not.
mention before the
Then I'm sorry, I have instruction to withdraw and try before the court below trial.
Okay.
If I'm not granted, then I will come again.
That's my instruction.
Item 1 and 4.
1 and 4.
Problem.
May it please the lordship. It's a charge-sheeted matter, and matter is presently pending for supply copies, my lord. So, 439 application, my lord, and charge sheet has already been filed in this matter, and presently it is pending for supply of copies and claiming of charges, my lord. So, if lordship may kindly call for the LCR, and thereafter lordship may kindly consider my prayer.
You can fix it LCR along with CD.
After vacation.
After vacation, and it is 26. 24.
Ma'am. And big problem. GPU.
Make please, Your Honor. Well, it's a second time before. Earlier order, Your Lordship will find page 53. Your Lordship was pleased to reject, my lord. So I pray for my lord, because after that there is no progress in the trial, my lord. So Lordship may call the up-to-date, my lord, record.
Yes, it's not.
Scan copy may be called from, my lord.
Yes, scan copy along with the case diary and the status.
Status.
So present status.
Status report will be required, my lord.
Present status of the
My
case. It's not 27 can be. Well, putting it on 22/7.
My lord.
From the session just come.
But
From the session just come.
yes, we call.
26/7. Immediately after vacation.
It after 6:70, there are lots of methods. So we
22.
All right.
My please, Lord. My Lord, this is 439 bail application, my Lord. My Lord, petitioner was arrested, my Lord, on 14th April, my Lord. And the FIR, my Lord, kindly say page, my Lord, 9. This case is registered, my Lord, under, my Lord, section 21B and 22C, my Lord. This is deals with, my Lord, commercial quantity, my Lord. In fact, my Lord, the item which has been seized, my Lord, which is, my Lord, lesser quantity, my Lord. My Lord, I have also annexed, my Lord, a seizure list, my Lord. That is page 13, my Lord. Last part, my Lord. Total 25.05 gram of suspected brown sugar. But, my Lord, commercial quantity, my Lord, as per notification, my Lord, 250 grams, my Lord. This is much lesser quantity, my Lord. And now petitioner is, my Lord, today is 74 days, my Lord.
Yes, but the question is that it is both the section 21 and 22 are there. In 21 it's obviously B, and
My lord.
22 it's C.
That is true, my lord.
So, but where is the other decision? Because one is 21B, that
Yes.
means they admitted in the intermediate.
No, my lord, 21B, my lord, there is no ingredients of 21B, my lord. Sorry, 22.
But it has been registered under 22C.
Yes, 21, 22C is totally, my lord, absent, my lord. Because
may
20
kindly come to the page 17, my lord. Page number 17, my lord, the second paragraph, my lord. Thereafter, 22 bottles cough syrup recovered, my lord.
My lord, 22.
That is, my lord, commercial quantity.
22 bottle cough syrup, my lord, SCAP, my lord, which is totally free of, my lord, codeine, my lord. But here in my lord,
You are saying it is free of codeine phosphate, but I don't know. As per your, it is the codeine phosphate free.
yes, my lord,
Maybe.
then my lord, FSL report as well as CD. Yes, my lord.
It is there. I don't know, but
Short.
after FSL report to be turned, there may not be presence of heat.
Now, my lord, 74 days, my lord, behind the bar, my lord.
But case is registered under 20. We have to
That
call
is
for
true, my
the
lord.
inquiry, and if we try to call for the FSL report also.
My lord, short date may be given, my lord. Immediately after vacation, my lord. Yes.
My lord,
Immediately after.
19, my lord. 19/7.
Yes, that immediately vacation we are paying this time.
Oh, bless.
Hey, pleasure, Lordship. 439 application. Here in this matter, Lordship, I am a 61-year-old retired ONGC employee and also the landlord of the rental premises where the informant happened to stay with one of the rented persons to whom I have rented my premises through a legal agreement. Now, the entire basis of the FIR, kindly peruse to page number 14, that is the relevant portion of the FIR. There it says that being the landlord, I am having knowledge about the visit of such persons and had never tried to stop such activity. That is in the last portion of the FIR, page number 14. It is further stated that Nilakantha Pegu, I am Nilakantha Pegu, the landlord, though being the owner of the rental premises and having knowledge about the visit of such persons, had never tried to stop such activities. That is in the FIR. Now, kindly peruse to page number 24, that is the forwarding report. Page number 24, that is annexure C, my lord. Here also, in the section brief of the case, if we just go down below to the middle portion, may I, my lord? The owner of the rent house, Sri Nilakantha Pegu, 61 years, live in the ground floor of that building, where some boys and girls come to the rented room frequently. But he could not be asked about those boys and girls, why they come to this rented room. Now, my lord, I stay in the ground floor with my wife. The first floor is being occupied by Power Grid Guest House. And the second floor, this particular informant was staying with one of the rented persons. Her name was Bijumoni Dole. Now, this informant, when she had come to this house, rented room of Bijumoni Dole, I had no knowledge because Bijumoni Dole was the only legal rented person from my end. See, kindly peruse to page number 26, Annexure D. That is the agreement. That is the agreement. 26, page number 26, Annexure D. The relevant portion. Here, this Srimati Bijumoni Dole, along with few other persons, along with her daughter, also Sunu Goeri, who is also a co-accused in this particular FIR. She is also being implicated, her daughter. Now, they were staying, and this informant had happened to come like 1 month back prior to the lodging of this FIR, along with her 2.5-year-old daughter. And when she had come, this Bijumoni Dole, it is alleged that Bijumoni Dole had forced her and locked her inside the room and had forced her to commit some immoral activity. Then again she says that this Bijumoni Dole when she had refused to do so, had taken to one hotel at Bogamu, where she was made to undergo such activity. Now, regarding this here, I am absolutely innocent because I am the owner and I have nothing knowledge of this. Yes, I know some people coming there because guest house is also there, and I do not have the authority to infringe their right of privacy. So, my lord, at this moment, I would pray that let a CD be called, and in the interim, I may be protected. And if there is any material, then let this interim be vacated, my lord, if it is any material is there. Because I am a 61-year-old retired employee, ONGC employee. I am a pensioner having a good reputation. In my entire career, I would have never thought of being implicated in a activity which is beyond my imagination. Because Section 3 of the Immoral Trafficking Prevention Act is there. That means I am running a brothel, something like of that sort. But here I am renting a house. I am a legally landlord who is renting it, and that is much. But now the police have apprehended me and have taken me into custody just on the fact that I was not able to answer why they are coming. How can I say why they come? I see people come there. In fact, there's a guest house also. So maybe they come to the guest house. I'm not supposed to inquire about that because there are people who are vested with that job of inquiring why they are coming and whether is such activity is being taking place from my premises or not. But as a respectable senior person, a retired employee, or ONGC employee, I am being dragged into this matter unnecessarily, my lord. So let this the CD be called, my lord, and in the meantime I may be protected.
My lord, as per the allegation in the FIR page 20, my lord, আৰু ভাড়াঘৰৰ মালিক নীলকান্ত পেগুৱে ৰুমটোত অহৰহ মানুহ আহি থকা দেখা দেখিও কোনোদিনে বাধা প্ৰদান কৰা নাছিল. This is the allegation, my lord, although, my lord, that 376, my lord, that is directly not even mentioned in the FIR, my lord. So at this stage, my lord, I'll pray to call for the case diary.
In the meantime, I may be protected, my lord, because of the fact that since I'm a 61-year-old person having some reputation, if any material is there when the city comes, then let it be vacated. In fact, your honorable, this court has given interim in 439.
Power. One. But you rented the house to Bijumani Dole.
Yes, Srimati Bijumani Dule was the person to whom I have rented my one part of my second floor.
Where is
It will be not Lakhimpur police station to Lakhimpur.
CTM block?
Yes.
No, okay. That is it. Get what is that?
Those were given interim, my lord. My submission may be recorded, Lord.
I have it.
So then after vacation, my lord. 29/7, my lord.
Obliged.
May I please your lordship? Intermediate quantity lordship after vacation. It's from Jalukbari PS lord.
It's
2 kg ganja.
19/7.
Lordship. Much obliged, your lord.
May I please your lordship? Lordship, item number 33 and our item number is the same affair. So matter may be 33 and our item number is the same affair. So matter may
So
be
your one is 47.
47.
So 33 and 47 are same.
Same. So matter may be taken up together.
33, your lordship, we have not received the case diary, my lord. So, my lord, we will fix a date, my lord, along with the item number.
Lordship, earlier date CD may be written, I think.
Achha.
Yes.
Morning of 150. Then, my lord, at 2, my lord.
It is written.
My lord, if it is available, my lord,
Yes.
Okay.
we'll verify, lordship, if CD is available, my lord, at 2 p.m. my lord.
Okay. Both 33 and 40?
47.
No, it's 33. 33 to go to good. Sorry, Patina.
Different matter, different case. Police station is different.
It may be, my lord, our mistake, my lord. Because our petition is not matching with the, my lord, case item listed in the causes, my lord.
Here, so it is of Bongaigaon.
Yes, my lord. It is correct, my lord. But
47 is Bongaigaon. I don't know what is
my lord, it is our mistake, my lord. The wrong petition has been sent. So we'll at 2 p.m., my lord.
May I pray, Lordship? As a petitioner, your before Lordship and respondent, they are husband and wife. And due to some dispute, respondent wife, she filed a maintenance case. That was allowed, that was 2000. Then she preferred revision before the district session judge. That was enhanced at the rupees of 5,000. Thereafter, husband filed divorce petition, that was allowed. Thereafter, wife preferred matrimonial appeal before this Honorable High Court, that was dismissed. Thereafter, wife preferred petition 127 for enhancement of the maintenance allowance. That was allowed up to 8,000, Lordship, from 5 to 8, including all the area during the COVID period, Lordship. So my prayer is that, so it is now 8,000. And after the divorce, matrimonial appeal was dismissed, I got second marriage, Lordship. That is the last page, Lordship, 51, Lordship. Now I am with the second one. Present wife legally married, Lordship. Now my little simple prayer is that at this stage, Lord, notice may be issued and the order passed by the trial court, there is 8,000 to the wife by increasing 5,000 to 8,000. That may be fair, Lordship. That is simple. Because the amount of that I am getting.
The question is that she filed a petition 127.
Yes,
that is enhanced.
Yes, sir.
So why don't you take that same option? You have also the right to file another application.
Yes, it's rightly filed, and my the amount that was.
No, I'm not there.
Yes.
She filed a 127.
Yes.
That is allowed.
Yes.
It enhanced up to 8,000.
Yes.
So after the second marriage.
Yes.
Some situation or circumstances may be changed.
Yes, yes.
So you can also file, you have the liberty to file another application of 157 itself for reduction, modification. For
Yes.
Why don't you?
That, I guess that order we have came, Lordship. Petition filed by the wife, 127, against daughter we have came, Lordship.
But
That
there's
is-
no bar at all.
Yes, yes, no, but yes, yes.
Petition by you also.
Yes, 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 yes.
That's fine.
So,
Yes. Any other trade?
that is only prayer, Lordship.
So we are issuing those now?
Yes, Lordship. And if Lordship permit that order, because 5,000 I am paying.
5,000 was
I'm
there
paying. I
today
mean,
your wife is single or she has any?
no issue, no, it's not it yet. Second wife is not yet issued, Lordship. I'm now with my wife only.
No.
First wife is not,
First
first wife is
wife
single, Lordship.
Single.
Single, Lordship. After some time she left.
What you do?
I am BSF family, Lordship. Army personnel.
BSF employee?
BS.
What they are saying? You should not. A BSF employee,
Yes.
Mr. Dilip Dey,
Yes, Lordship.
Archer. One. But it's continuing.
Pardon?
So that in that case, can copy it?
Yes,
Or
yes.
write?
Case is disposed now. Case is already disposed.
Okay, then copy. And, no problem. Okay, let's take up the tape.
Yes. Okay.
Please, Your Lordship. Lordship, this is a revision against the impugned order dated 10/4/2024, by which the check was sent to the handwriting expert for his opinion. Now, what has happened, Lordship? I had filed a complaint under the NA Act, and then there was a check, 3 checks, and the defendant, he admitted that he has signed the check. Only thing he did not admit is that he said that I did not fill up the content. But then the Supreme Court decision, you signed and you issued the check to me. Thereafter, now he wants to send the check for handwriting expert. The CGM refused. He went on revision, and the additional session judge allowed the petition. I'm aggrieved by that one because admitted facts does not have to be proved, and moreover, the opinion of the handwriting expert is not binding. His defense is to show that I was not a receiver of the check in due course. Instead of that, it's just to delay the entire process. That's my revision. Okay, I'm praying for notice and pending stay of the order of the additional session judge. I'm praying for notice at this stage, Lordship. Because that's a redundant exercise, it's only a waste of time. The impugned order is at page 25.
Supposed to pray for stay of this the order filed by the additional
Yes.
citizen. In that case, what the days of the other?
The rest proceedings will go on, Lordship. Any other evidence will go on.
If there is a question that if the handwriting is supposed it's only signature of the
But the signature is admitted, Lordship. Signature is admitted. Only the name and the amount is not. Yes.
where it is there, signature.
Because
Have you
this-
annexed any
Lordship?
that he admitted his signature, whether there is any statement made by the
I have not annexed any statement, Lordship, but there is there in the orders itself that he has admitted the statement. In the evidence it's there. Even in the order it's there, no? Even in the order it's there, Lordship. Huh? It's there in the order. Page 19 it's there.
19.
19. And Lordship, and page 21 also. And even in the other. Where? The main contention 21 is that the check had to the complainant had not discharged the debt as liability claim. That means the accused is admitting the signature on the checks of this case. In this case, that is the observation. And there's one more. It's in the CJD. It's not indictment also. I'll just show Lordship. I just Lordship, page 30. Page 30 of the petitioner had appeared before the learned CJM Tinsukia and in his written plea of defense denied issuance of the check on this to the OP number 2 in lieu of financial help of rupees 10 lakhs at alleged. But the OP number 2 stated that the OP number 2 never paid rupees 10 lakhs to him on 12/1/2019. He stated that in the month of November 2018, he approached the OP number 2 to hand over the original agreement of sale executed between Sri Rupin Gupta and the OP number 2, and the same was required to him in connection with title suit number this. In lieu of handing over the said agreement, he handed over 3 signed checks, 3 signed blank set checks, as security to OP number 2 without putting the name and date in the said check. Signed check he has it.
Formal part.
Not it? Yes, formal part.
It's been ordered by planet. It's different. Code. Whereby they are out there made by in and I one of it but check so they denied certificate for for it what the credit not therefore it does yeah but by the different number 4 packet of photo well it set it Okay.
Obliged.
May I beg your lordship? Lordship, this revision petition is against the judgment passed by the additional CGM Bongaigaon in Miss Case number 3 of 2020. Lordship, may you please peruse page number 86. Annexure 10. Whereby the Honorable Court has directed to pay rupees 3500 as maintenance to the respondent, whereas the petitioner is already paying rupees 5000 as per the DV Act, Lordship. It is in page number 25, Annexure 3.
DP was finally disposed of.
Yes. And the petitioner is already paying rupees 5000 per month. And there is a screenshot also. It is in page number 44. And after this DV Act, the petitioner has filed a restitution petition also to bring back his wife. But there is a judgment of restitution also. It is in page number 45, Annexure 5. But the respondent did not come with the petitioner, Lordship. And it is very hard for the petitioner to maintain both sides. Like family for himself also and his ailing parents also, Lordship. There is ailing parents of the petitioner also.
While passing the order in the maintenance case, have you produced the order of the DP? And the order was passed on 21/3/2022. And this order 24.
24. It is in 24. After the restitution petition, when the wife didn't come, the wife has filed a title execution case also. And finally, when there is a conflict between them, then the petitioner has filed the divorce petition, Lordship, against the respondent.
I'm asking you when the DP order was passed at the time. Maintenance order was passed. Have you produced the order of DP case? Because it is 2020. That was the order was passed on 2022, and this order is passed on 2024. And you have annexed only one 5,000 thing. That part is done. Stop payment. Only one screenshot you have submitted that about this is the interim order.
Which one? Maintenance.
This order is the interim order.
Yes.
No, judgment.
It is the final judgment of the maintenance. 125.
Obviously, if you're paying 5,000 DP, then 3,500. I don't know what they did. They adjusted the final cost. Let them appear first.
Lordship, interim.
Wait, confusing one. We have not submitted all. whether it was passed earlier or subsequently, if the production of goods were brought before the court or not, it's not clear. And it's also not clear that as to whether you are paying the DP amount.
I'm paying the DP.
Not sufficient. No order is there. Why you have five furnished one screenshot that for 1 month. Know whether he is continuing or radically not because it's a maintenance case. Let them appear first.
May I please, my lord. So the applications under the 397/401 and 482. My lord, the petitioner is the registered owner of the vehicle which has been seized in the year 23/12/22 in connection with the PS Jinjia.
So where is the order? Impugn order?
Impugn order is page number 57. 67, my lord. We have applied for the JIMA before the learned court, Bishwanath Sariali Special Court, and JIMA petition has been rejected on the ground of it is reflected there in the order dated 31/5/2024. Charges have been already completed, Your Honor. The trial is yet to be started, and the vehicle which has been seized, I am still paying my installment since 22 to till date, and whereas the vehicle is lying in the custody of police station.
So this order was prior to filing of the charges?
After that?
After filing of the charges?
Yes.
No, this order of 31st of May, the order passed by the additional judge.
31/5/2020, this is the last order, whereas the charge sheet has been filed in the year 2023.
It was also mentioned in the order, my lord. Charge sheet was already submitted.
Submitted.
Charge sheet is on. After charge sheet you have filed it.
My lord.
My lord, in the 68, page 60 regarding the vehicle, my lord, Zimma, they have prayed for but was rejected, my lord. 68. But provision of the case of particular order is so and so, which are requisited vehicle bearing so and so, which is in process of confiscation. Letter part. Also see the letter that so and so submitted before the Honorable Special Court so and so, which also wrote clearly that vehicle bearing registration number so and so has already confiscated in connection with the incident case so and so.
As per from the order, it people said they have asked for a report from the authority, I mean the investigation authority.
That's what
and
we
where
are.
from it is seen that it has already been confiscated.
They have not followed the due process, though they are saying that it has been confiscated, but their due process has not been followed. Because prior to that, they have not given us an opportunity for the hearing. There are a number of judgments. For example,
We know the opportunity of hearing.
yeah, that was not given me, where I was deprived. As I am deprived, then only we moved a JIMA petition before the Honorable Court Special Judge Bishwanath Sariali. Then they have rejected, and they went us to prepare before this Honorable Court.
Oh no, date is there, no?
My lord, date is there.
So it wants that it call for or
My lord, record. Call for the record. Issue notice and also call for a record.
the record
My lord.
recording it later.
My lord.
And the figure or
My lord.
that record is it by where the maybe in the case guide also.
My lord, it is
already
not
charge sheet submitted, my lord.
No, RPC subject, we will call for the copy along with the
Minor.
But I am on that where the confiscation proceeding was initiated by the corporation. Whether that record they maintain and the record that these allegations that they have not served with any notice, no the opportunity of hearing was given to them. While the order of confiscation was passed. So where will they?
That is
My lord, that's what when we approach, we have sought for that also, a confiscation order, but we have not been provided. So that is where we have been deprived of my right.
record and CD, my lord. Record and CD, my lord. Then I will
CD may be available.
My lord, along with the record. LCR and CD.
It should be obviously after vacation.
My lord.
After you want anything,
Yes, Your Honor, please.
then otherwise it should be after vacation.
My lord. Bibliothèque.
May it please the Lordship. Lordship, the complaint is at page 45, Annexure 6. My Lord, this is a pure civil dispute. I, the petitioner, have bought the land in 2014 and the registration and the NOC was issued prior to it. And thereafter my name had been incorporated in a Jamabandi copy. Now what does the complainant does? He files a police case in 2024, 8th of February, stating...
You're saying you have purchased the land.
Yes, I have purchased the land. My lord, there are proper records. Even my name, NOC is there, my name is there in the Jamabandi copy, and even the sale deed also I have executed, my lord. So it's there, my lord. May I just take you through the records, my lord? So now, my lord, the complainant, what the complainant does, the complainant, first of all, he is not even related to the person whom I have brought the property from. In his own statement, he says that I became the owner of the possession of the said land. But if you look at the Jamabandi copy, my lord, he is not even the father, he is not even the son, he is not even relative, nothing. Only the surname matches. And he comes and he says in the year 2024, 8th of February, that the land whom he has, I have bought, that is not his land, it is someone else's land, and they have impossessed and bought the land. I have impossessed. And he has said that I have impossessed to be someone else, and whom I have brought from, he also has been impossessed to be someone else. Whereas, my lord, the government records and the entire records and has been the process as the due procedure of law has been followed. So even if this criminal case is filed, my lord, this is absolutely has been taken up as a civil dispute. Because, my lord may see, the criminal court cannot give him a title over, cannot give him the title over the land, if there is any dispute, even if so. And as of today, 12 years of possession has already been conferred to me. So, my lord, this is only to extract money and to harass the petitioner. Because he's a retired employee. For 12 years, the person did not do anything. So, I'll just read the complaint once here, my lord. With due respect, I humbly state that Lal Singh Agarwal, son of so-and-so, was a joint original owner in possession of the land measuring 5 bighas covered under so-and-so. And after that, I, along with Subkan Agarwal, that person also died. On 13/6/2006, Purushottam Agarwal died on 23/2001, became the owner in possession of the said land. He became the owner in the possession of the said land after 2021. It is to be mentioned here that the Pattada number 1 died on 9/8/73. Surprisingly, the accused number 1 alleged to have been purchased 2 bigha of land from late Lal Singh Agarwal and got his name mutated only on 10/8/2009 by right of purchase without giving notice to us. The accused number 2 also got mutation dated in respect of 1 bigha 2 katha 10 lesa, and the accused number 1, 2 subsequently shown to have been sold the aforesaid land to the accused number 3 to 10. Collusively by playing fraud with the lot mandal accused number 11 to 14. In fact, we the original Pattadas never sold any portion of our aforesaid land. The accused number 1 to 2 have prepared sale deed representing us by personifying a thumb impression, foregoing signature, and shown to have been registered sale deed by playing fraud collusively with the sub-register and got mutation without serving any notice to us with a view to grab our aforesaid land for the wrongful gain. I made in search of the office of the sub-register to obtain certified copy of the same if any such register or any trust has been found till date. I therefore request you to plead to investigate in the matter, register a case against the accused person and take necessary against the dam as per law. Now, my lord may see the enclosed is a copy of Jamabandi. He did not even enclose the death certificate. Other person has died. Now, I have enclosed the Jamabandi copy as found in the Dhayatri website, my lord. Now, my lord may see at page, annexure 3, page 35. My lord, the Lalsim Agarwal names comes at the top. My lord, Father Ramchi Agarwal. Now the complainant names come at 4. Devidat Agarwal, Father Kanjam Agarwal. Not even related. And my lord may see at the right hand side, my lord, petitioner Srimati Bondita Deka self-evident is Deka is allowed under Ramji Agarwal. It was been allowed by the DC office. At the right it has been there, my lord. My lord may find it, my lord. Now, my lord, my name is at 9. Kishore Kumar Sharma. My lord, then on the right hand side, registration in the name of 1, 2, 3, 4, 5, 6. Registration in name of Kishore Sharma, Vijay Chandra Sharma under Logot Kharidas Khutra Habe, corrected signature Azizur Rahman, so and so. And order number circle matters. Now, my lord, this was done as per the due procedure, annexure 4, page number 38. My lord may see this is the NOC certificate that was issued to by the additional DC with the proper. This is to certify that the Commissioner Kamrup County has no objection to page 38, my lord, annexure 4. Sri Vishwajit Goenka versus Kishore Kumar Sharma, the complainant, the petitioner here, my lord, the buyer. Dispur Beltora Kharguli, new patta number so and so. And accordingly, my lord, the deed was registered. The registration of the deed is at, my lord, page 14. My lord, and at page 21 is the impression, the photographs, and everything. So, my lord, even if this complainant is trying to say that this land is not, this is a civil dispute in all nature. And now when I have already acquired the right, as per the law and as per the procedure adopted, filing a criminal petition, that too after more than 12 years, and this is prima facie it is to harass me and to adduce money from me in some way. So, my lord, I pray for stay to a proceeding relating to Kishore Kumar Sharma, my lord, because the entire documents are clear, my lord. My lord? No, my lord, in charge. My lord, the law is very clear, my lord. This is a recent judgment of the...
My lord, here, although civil in the nature, my lord, but there is some materials against the petitioner also, my lord. Additional lordship notice maybe...
Now, this is the prima facie issue. It is a case,
my lord, my lord. Not my lord. After it was prior to respect, my lord.
Everything has come detailed in the...
Mutation was done, my lord, also. That was. My lord.
My lord,
lordship may call for CD, my lord, and notice may be issued, my lord, and lordship may call for CD, my lord. After that, lordship may consider their interim prayer.
My lord may see, my lord, there is nothing in the FIR against me. My lord, page 44. There is nothing, my lord. My lord, entirely...
That is the model apparently now prevailing in
my lord.
Some you got mutated your name, everything will be there. Without behind the back of the original. That is the case. That is going on.
My lord.
That's the reality.
My lord, may I just submit here? No, my lord, this...
Otherwise, you can see that it's you have purchased the land, 12 years of possession, you got mutated.
Sir,
but
my
the
lord...
question is not there. The affair is not there. They're telling that the person has been impersonated someone.
Forging the document.
My lord, but that...
Everything is there.
I absolutely, my lord, may see the FIR, my lord. I just see the FIR, my lord. And my lord, in the FIR, the charge sheet also is there, my lord. My lord, how can... no, my lord, sorry, in the 44, my lord, the FIR, the detailed FIR is there. My lord may see that it... Yes. My lord, it is not... The language is very simple, my lord. It is against the accused number 1 and 2. I am not the accused number 1 and 2.
No, it will be clear from CD, my lord. CD itself, it will be clear what is involvement,
but
how they are involved, my lord.
My lord, may I just submit? I am the owner of the land. So even if he has not alleged against me that I have impersonated, because I buying the land, I cannot impersonate. My lord, that is clear from the FIR. How can I impersonate with someone else, my lord? So, my lord, what I am saying is this, my lord, only on the other accused, my lord, the investigation may be carried on. But against me, my lord, how can I impersonate with someone else?
Cannot stop it.
My lord,
You Mr. S.P. Sharma?
yes, my lord. Some kind of protection, my lord.
For what?
Notice to the
response.
Two.
No problem. Also for prayer for
No. Call for CD, my lord.
Hello, some kind of protection, my lord.
My lord. After vacation, my lord. 25th, my lord.
Hello, some kind of protection, my lord.
You can pray for bail or if you have any.
My lord.
No, I'm already on anticipatory bail, my lord. I'm already on anticipatory bail. There is nothing. But my lord may see this. Just I know my lord has
What kind
passed.
of interim protection do you need?
My lord.
If you are on interim protection, आप interim period पे call period देगा बने. So there obviously there not.
No, there is no code. My lord, because I'm just saying here, my lord, because the person, how can a person who himself can impersonate as himself?
Going on now.
My lord,
prevailing now.
That is why I was.
Land matters, see all these things are going.
Yes, I understand. But that is why I have shown the.
It is for people for the sub-register office.
Yes, my lord, but this was 2014, my lord.
Obviously.
Lord.
May I be your lordship? Lordship, by this petition, lordship, I am prepare this criminal petition against the judgment of the learned session judge, lordship. Lordship, what happened in this case, lordship?
482 is against session judge.
Lordship,
How?
lordship, I am submitting, lordship. What happened in this case, lordship? The petitioner, lordship.
It's okay, but the question is you have filed this petition against the judgment passed by the learned session judge.
Learned session judge asked in the revision, criminal revision.
How, Mr. Kusami, how is it possible?
Yes, sir.
482 here?
Because there was a revision and session judge passed this order in the revision, lordship. Against the revision order, I am filed this criminal petition. What happened, lordship? The petitioner, lordship, filed an application to the lordship, page 13, lordship, before the additional district magistrate Hailakandi, lordship, that the respondents are trying to occupy his land, lordship. And thereafter, lordship, a police report was called for, and the police report, lordship, page 18, lordship, and police submitted the report, lordship. Then what happened, lordship? The district magistrate, lordship, passed an order, page 22, lordship, an interim order, lordship, interlocutory order, lordship, page 22. Page 22. May I read, lordship, the relevant page, paragraph is page 23. Under the above facts and circumstances, I am satisfied to draw up a proceeding under section 145 CRPC requiring both the parties to appear in person in the court and file WS along with their valid original land documents. Further, according to the police report dated so and the urgent situation arises in the locality for taking physical possession of the land by the second party members, there is every possibility of grove clashes between both the parties and consequent breach of public peace and tranquility in that locality. Hence, in view of the above situation and being satisfied on the basis of the police report and complaint petition, I do hereby invoke the
provision under section 146(1) CRPC and attach the DL as per mentioned in the schedule length and prohibit the entry of the parties till next date fixed for maintenance, peace and tranquility. Lordship, this is the order. Lordship, it is completely an interlocutory order. Against the order, the respondents approach to the session court, Lordship, by filing the Lordship page 24, the revision petition, Lordship. And in this revision petition, the learned session judge, Lordship, passed the judgment, page 34, Lordship, setting aside this order, Lordship. And my respectful submission is that the learned session judge, Lordship, has no power to enter the division jurisdiction, Lordship. Lordship, as per the section 397(2) of CRPC, Lordship. May I read the section, Lordship? May I read, Lordship? Section 397. Calling for records to exercise powers of revision. The High Court or any session judge may call for and examine the record of any proceeding before any inferior criminal court institute within its or its local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality or probability of any findings, sentence or order, recorded or passed, and as to the regularity of any proceedings of such inferior court, and may, when calling for such record, direct that the execution of any sentence or order be suspended, and if the accused is in confinement, that he be released on bail or on his own bond pending the examination of the record. B, Lordship, subsection 2, the powers of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial or other proceeding. Lordship, under this section, Lordship, the learned session judge has no power to exercise divisional jurisdiction in case of this, Lordship, interlocutory order, Lordship. This is my humble comment, and the learned session judge has power beyond his jurisdiction, Lordship. And in a similar
145 proceeding, my lord. But generally, my lord, against that, my lord, revision lies in the session court, my lord. Whether I have to take the section. Yes, because
Lordship, there is a similar Lordship case, Lordship. The coordinate bench set aside the session judge order, Lord. And another case is also pending, Lordship, where the a criminal petition, Lordship, 492, Kabiruddin Wadbhuiya, Lordship. And paragraph, Lordship, paragraph 6, Lord. The relevant page is, Lordship, paragraph 6, Lordship. May I read? The learned counsel for the petition has submitted the order dated passed by the learned ADM Hailakandi in under section 7 is an interlocutory order in nature, and accordingly, as per section 397 to CRPC, the revisional jurisdiction has no jurisdiction to exercise the power of revision in relation to any interlocutory order passed in any appeal, inquiry or trial in any proceeding where the learned session just failed to appreciate the provision of law and pass the impugn order dated so admitting the said provision.
Power to revision.
but he's saying that it's the interlocutory order. Yeah.
Yes.
But if you go by the order of the session also,
Yeah.
it's that it was just remanded back.
Yes.
We can right given opportunity to other side for hearing.
Yes, only that much. Otherwise, my lord is
Because behind the back, the allegation is that behind the back of the division petitioner,
Yes.
the order was passed.
Yes.
That's why court directed.
Yes, that is why the court directed. Yes.
So that the order can be passed if they are present and
Yes.
hearing both parties.
Yes. That is.
Obviously, it is an against the interlocutory order.
Yes.
But they have agreed.
Yes, because.
So we are issuing notice anyway.
Yes.
Lordship may issue notice and the impugn order may be suspended, Lord. And in a, Lordship,
Impugn order is for your benefit also.
Lordship,
It's a simple order that you appear before the court video and giving an opportunity of hearing, it will be heard. That's
Court,
not the
court will, my lord.
session class judge has remanded back the matter. It is only with the direction that the
So I am not paying the staying there in the additional case, lordship, additional magistrate. The impugned order, the judgment may be.
That's what I'm saying. That is,
Because in
the
the-
order is passed that so that the other side may get a chance of hearing or opportunity to say that much. So what is the ground for stay?
Lordship,
Maybe right.
I have I have placed the honor another order, lordship.
Okay, you have placed it.
There also the case is pending, lordship, and the impugned order was also lordship stayed, lordship. I have submitted, lordship.
Where's
The
No, your additional magistrate matter is pending.
lordship.
Before the additional magistrate, the matter is pending.
the-
Additional, the district magistrate.
This no, lord.
It is already disposed of?
Disposed of,
145?
lordship.
You are saying just now, you are saying there
The
was.
session judge disposed of this matter by this judgment, lord.
No, I'm not. The magistrate, executive magistrate.
There is pending, lord.
And this pending.
Lordship.
Therefore,
Lordship, the impugned order passed by the session judge may be suspended because he has exercised his jurisdiction beyond his jurisdiction, lordship.
come later on. But the question is that the matter is still pending before the executive magistrate.
Lordship.
So you, both the parties are to appear before the court. No hard at all.
Lordship, they will appear, lordship.
Yes.
But here I am against this impugned
Because
judgment.
you got
Lord.
the order behind the back of the other side. That is the allegation. Without hearing the other side, the order has been.
It is said by the session judge, lordship.
Session judge, the petition was filed before the session judge only with that allegation.
Only on that ground that they have not been.
They have not provided any opportunity for it.
Whereas, lordship, before passing this order, notice was issued. They were appeared.
Yes, I mean,
Whether they have appeared, man, that is.
appeared.
They have appeared, man.
They have already appeared.
They appeared, lordship.
They and
Volume, lord.
Impugned order, man, page 2. Page 2, man, impugned order.
Page 2.
Page 2 there, no?
Page 2. 32.
Yeah, I got to. I got to. Executive order.
Oh. 22. 22.
The order of
This is a clear finding that the order is given ex parte, considering the urgency of the situation, man. And he said that they have appeared, man.
And both the parties.
appeared.
They have not appeared.
That is it.
No, no,
He is saying they have appeared.
The order is given ex parte, considering.
no, lordship. In the impugned order, kindly see, lordship. The session just said, the lordship pointed out there. If we finish the impugned order, when we come in, the case was fixed on so and so, as the case was put up on on-pay and the matter was impugned order was passed. Lordship,
Yes. State only.
right, Lord.
And the other matter is still pending.
Lordship.
That's why it happens.
LCR and court, obliged.
In that case, what will happen? The other side will not get the chance.
But here, but they have, because notices also both the parties that notices are issued, my lord.
Issued.
The next date was given. Next date fixed is before 22/11. कितने किस को ये तरह मेरे? 22/11 is the next date.
11.
Page 22, my lord, my learned friend is using page 22, lordship. The order passed by the additional May 23.
Here,
It was 2211.
here the next date is 22/11/2023.
So they are to appear before the
What happened after
additional
that?
magistrate.
On 22?
But without appearing the additional magistrate, they approach to the session court, lordship.
No, that we can one state from the order of the Danish Session Judge.
Yes.
But if that proceeding may continue. Yeah.
Lord, it will continue, Lord.
Otherwise, no, what is the present status of the case?
Lordship?
That is not clear, ma'am.
As far
What is the present status of the case which is pending before the execution?
it is pending, Lord.
Just pending.
Pending.
That should
It will go, lordship. Session calls, if the session judge order is, lordship, here before your lordship is that the legality and validity of the order dated 21, lordship of session judge. So if it is stayed, lordship, the pain case will go, lordship.
whether we can direct put oh, you cannot.
Because notice has to go, my lord.
Notice. Apply, Lord.
Yes, I mean.
Here, this application is filed against the order rejecting my Jimma of detailed narcotic. Probably reports will be required in this case. Page 30 is the impugn order. The learned magistrate was apprehensive of the fact that although FSL report is not received, the betel nut will be unfit for human consumption. Only on that apprehension he rejected. Although some documents were submitted.
But, by this time, whether report is already there or not?
No, after rejection I do not know, but at the time of rejection it was not there. Report was not there, and in fact I filed bail application before this honorable court along with the documents that the IO was directed to verify the genuineness of those documents. And after that case diary, perusal of case diary, this honorable court made that interim order absolute. There was nothing adverse, but IO submitted a report that I could not ascertain the order. Although all the documents were there, and FSL report is not there, but still the learned magistrate he cannot sell. And if it is found to be unfit also, then also our division bench judgment is there. It is not the lookout of the customs or other officers. If it is used, then that cause of action will arise. Before that, no one can be there. Just I am referring to the certain
It's
division.
okay, I know that. The question is that who will assure you that is
Yes.
the question.
Only that
Because if it is not fit for human consumption
Yes.
of it,
That only undertaking is
if
required.
it is in your favor,
Okay.
that assurance has to be there. You are not doing it for the human.
Yes, that undertaking I have to give to the
has to be
SP.
there.
That undertaking I have to give to the SP. But the learned magistrate said there is nothing on record. I do not have to give to him. He can direct me to give the assurance to the SP. SP will verify it.
So as per you feel the passing of the order by the Learned Court below, the FSL report was
No, it was reflected in the order itself.
Oh, hard discussion. Call for the some if we are calling for report and
Yes,
the
we are calling for
FSL,
the
FSL
press.
has to be there.
Yeah, FSL and press report. FSL and press report from the.
No, this is for the first time we are calling
No.
for the report. And call for the report not we call it. Before the after application or go on the application?
After vacation, any date may be fixed.
Date.
Yeah.
Yeah, I have already discussed many cases 3172 or 3172.
Obliged.
31. Just call for the report along with the FSL.
Obliged.
And for the time being, my lord, similar cases, our argument is going on court number 24, my lord. Similar petition, my lord, similar nature of case, my lord, same petitioner, my lord. What happened in this case, my lord?
You want
Here is the
to
respondent
keep it
number
for time
2,
being?
a respondent, my lord.
No, you want to keep it for time being or what?
For the time being, my lord. For the time being, my lord. Only 10 minutes, my lord. I think.
My lord, in this case, my lord, two proceedings are there, my lord. For the same relief claim, my lord. One earlier SIP file, one under DV Act, my lord, where the court below directed the petitioner to pay interim of rupees 8,000, my lord. That is the present case before your lordship, my lord, under DV Act, my lord. Thereafter, another petition was filed under 125 CRPC, my lord. There, my lord, the interim relief of rupees 4,000 was directed, my lord. Earlier, 5,000 was given, but in revision, it was modified to 4,000, my lord. So, at this stage, my lord, this amount may kindly be stated, my lord.
No, 5,000 and then 4,000.
So, 4,000 and 8,000. Present one before your lordship is 8,000, my lord. At the rate of 4,000 to each, my lord, mother and daughter, my lord. And on next, subsequently, another proceeding under 125, my lord. There it is directed to pay 4,000, my lord. Suppressing the earlier one, my lord. That has to be brought to the knowledge of the court, my lord. That is the ruling of the Supreme Court also, my lord. Honorable Supreme Court also. The earlier proceedings should be brought. She cannot enjoy two reliefs, my lord, at the same time, my lord. That is also what the Honorable Supreme Court also said in Hindu
So
Malhotra's
what is
case,
the order in criminal affidavit?
my lord.
The order of criminal affidavit?
Yes, my lord.
The order of adjustment was there, I think. Or is it not?
Page 23, man. In appeal that is against the DB Act order of interim management. That was rejected by the court below.
No, but you have filed this the petition against the order of judgment and order dated 21/5/2010.
Yes, that.
You have put to challenge that order.
That order also under challenge, my lord. That was also challenged and there 5,000 it was reduced to 4,000, my lord.
You're confusing me. Now I'm asking you the 21/5/2024 order you are being challenged. This order is under challenge.
Under challenge, my lord.
Then that order says that it be adjusted and all. Where is the order? You have annexed the order at way?
But that order, but it was challenged by that order under 125. Then it was increased into earlier 5,000 rupees. That was modified to rupees 4,000 by the learned session judgment in revision petition, my lord. Then I have an next, my lord. That is there, my lord.
No, where is the order of 21/5? First, go take up this order.
21/5, my lord. No.
Because your petition is...
Appeal,
no, 21/5/82.
Your petition is...
একটু হল রিভিশন হবে
against that order.
4000 করছে এপিলকে একটু ডিসমিস করছে আপেল রেখেছে 8000
Page 23.
You have annexed the order at page 23.
Page 23 it is there, my lord.
Yes. So,
Appellate order, my lord. That was rejected, but I have already stated, my lord. Last part of the order, my please tell me. Ultimately, it was rejected.
no, 8,000 was... Petitioner was asked to pay 8,000 as an interim in...
Interim, at the rate of 4,000 each the mother and the child. Mother.
In DV case.
Yes. In DV case. That is the present case before your lordship, which you have challenged, my lord.
That is the interim order.
Interim order.
And then what is your other order?
The other order, my lord, at page 28, my lord. That proceeding under 125 CRPC that was initiated, my lord. And in that order, my lord, rupees 5,000 was given initially, but that was challenged also, my lord, in revision. And then learned court session judge, my lord, modified it to rupees 4,000 per month, my lord. That order at page 28, my lord. So without disclosing the earlier proceeding, my lord, that is our case, my lord. That without disclosing the earlier proceeding, that she has been awarded rupees 8,000 per one as interim. Then this petition was filed and then this order was passed, my lord, interim order.
On the same day.
On a subsequent next day, my lord. On next day, my lord.
Same day.
On the next day, my lord. On 26, it was earlier 26/5. It was ordered 26/7, and the next order was passed on 27/7, my lord. What are interim orders?
No, in page number 28.
28,
Page
okay.
number 28,
Yes, yes,
the
ma'am.
appellate court most probably 4,000.
4,000, my lord.
It is also same date.
That is the same date, my lord. No, I'm speaking about the earlier or the first order, my lord, from before the learned magistrate, my lord. This is a revision petition order, revisional order, my lord. But revision is same date. No, not the same date, my lord. The revisional order was on same date, my lord. So that court would have considered that part, my lord, because the earlier order also, my lord, regarding that under DP, this maintenance act, my lord. 125 CRPC maintenance, my lord. So, so one order can be enjoyed. Both the orders, my lord, pass on the same date, my lord. 21.
So you want to, you are against the order of 8,000.
Now 8,000 before lordship, my lord.
Why not 4,000?
That is also a challenge, my lord, with another court, my lord. So let it be like, that is 50%, let it be blunt, no? Let it be 50%, my lord, because another 4,000 rupees he has to pay under the 125 CRPC, my lord. So let it be 50%, my lord.
You have paid anything till now?
No, the order is just passed by last month, my lord. So till now, no, nothing is paid, my lord. So let the 50% at least be paid, allowed to be there paid, my lord. Let at least 50% be allowed to be paid, my lord, now, my lord, in this proceeding, my lord.
In DB?
That DB, my lord. Because in the other one, 4,000 rupees he has to pay, my lord, in the other one, 125 CRPC, where interim relief was granted, my lord. So I'm not asking for the entire amount to be stayed, my lord. At least 50%, my lord, at least he may be allowed to pay in this one.
So if here we have reduced to 50%, then you are not going to pay the 4,000 also. What will happen?
That 4,000 also they are already there.
Here, they say it's also under challenge.
And but there is no stay, nothing, my lord.
No, stay in certain cases, stay is very difficult.
Unless, I'm not asking for stay.
He has come and
Yes,
just saying that.
So let us 50% may be right to be paid, because then in that case she will get 8,000 rupees. The 4,000 there and now here 4,000 in it. And some without even asking for stay, I am asking for minimum relief, my lord.
From Mr. Ema.
Mr. I. Hazarika. My name is not shown, but I have local.
15. From Mr. I. Hazarika.
I. A. Hazarika.
I. A. Name is not there. For the the deputy. Number 70 by Dani Digital Bongaigaon, whereby the epic was dismissed and upward the order was by the Dani and him. Bongaigaon, dated 26/11/2019. At CR is number 25 of the directly petitioner paid per month. The opposite party and her magnitude as both respond to this statement also both protect. Must have but it's that the petitioner also filed that they have also filed the case under 130. Where is the order? 150 order.
Let's say page 20, man.
58.
20, 20, man. First order, page 20. In revision, it was modified to 4,000 from 5,000. Revision order
It was for the final amount or it was also interim?
No, that was also interim money. At page 28 is that 28. At page 28 money. Interim to modify.
Pending report. Report of GMFC account. Peak number for very not that tasted that passed an order for it to be of 10,000 per month. To 5 and it by the and it will put that the amount. It's 4,000 per month. Make it on that the another order passed by the order passed in the case of taking the case under section 1 and however it pay 4,000% of interim basis passed in present passed in DP case number 25 of 20. As per order and as per the method here so we are going to pay 5,000 per month.
My lord?
As an interim, we are going to pay 5,000 per month.
50,000 my line.
5,000. From 8,000 and deducted is reduced to 5,000.
May I please your lordship? Lordship, this is a 438 bail application. The FIR starts at page number 11, the translated copy of the FIR. Lordship, the complaint has been filed by the police officials from Hallam police station, and the allegation against me is this, that while I was returning from Arunachal Pradesh in a nano vehicle, my car was stopped, and in that car, lordship, illegal liquors was found. And after that, lordship, I fled the scene. So, lordship, I admit, lordship, I had fled the scene, but lordship, I want to justify why I did so, lordship. Lordship, the actual facts of the case is little bit different. Lordship, I am a driver, lordship, and I was employed by the owner of the vehicle to bring, and I was under the impression that I was carrying vinegar, homemade vinegar from Arunachal Pradesh. But when this illegal liquor was found, lordship, I was panicked, and lordship, I fled the scene. I admit it, lordship. Now the thing is this, lordship, that I want to cooperate with the investigation. I want to appear before the investigating authorities, and I am ready to show from the source from where I bought it and the owner of the vehicle who was the owner. But I am apprehending if I appear before the concerned police station, lordship, I will be arrested. So therefore, I humbly pray that I may be given some interim protection, and the case record may be called for.
Well, the CD will be required, my lord. Otherwise, my lord, it is in the 9-star deluxe whiskey bottle, 6 cartons. Beer, 544 cartons, my lord. So, it cannot be that he is unaware of the fact, my lord.
Being a driver, how he was not could not differentiate between the vinegar
And vinegar.
Lordship, just pack, Lordship, in the cartoons, those cartoons.
and it's that's temperature, but
I'm ready to cooperate, Lordship. I will, whatever knowledge, information I have, I will share, Lordship. PP meeting, Lordship.
to the type of about so you are not aware of.
Lordship. These are my instructions, Lordship.
And okay, got it.
I'm deeply obliged, Lordship.
He shall appear, man.
I will appear with you.
Before I have it itself. It 5 feet. It will be on 5.
Yes,
5A.
If you appear with it,
I will appear, Lordship. I'm deeply obliged, Lordship.
May I please your lordship? 430 is bail application offence under section, my lord, 420, 468, 379, 411 of IPC and read with section 53 and 54 of Assam Excise Act, my lord. FIR, my lord, on page number 15, type copy, my lord. May I read the FIR, my lord?
yes.
Subject, first information report on detection of illegal liquor and duplicate bottles and labels at Siknibari in the premises owned by Sri Pankaj Kolita alias Pisla. Sir, with reference to the subject cited above, I have the honor to inform you that a team of excise officials of Excise Intelligence Bureau, Guwahati, with the assistance of the undersigned, detected a large quantity of illegal liquor as per annexure enclosed herewith in the premises of accused person, namely Sri Pankaj Kolita alias Pisla, son of so-and-so, resident of Dolungpar, PU Ulubari, District Tamulpur, BPR, Assam. On examination of incriminating documents found in the premises of the accused person, further raids were conducted at the following places and detected illegal liquor therein as mentioned below. Number 1, Sri Shandishar Narjari, son of so-and-so, Pramod Boru, licensee of PBIMFL of shop. Number 3, Sri Horen Kakoti, son of so-and-so, address so-and-so. On preliminary investigation, it appears that the accused person is involved in fraudulent manufacturing and bottling of illegal liquor
leading to endangering of human health besides causing loss to the state exchequer. Further, such fraudulent manufacturer deceived the consumer as cheap liquor, rebuttal to resemblance as premium liquor. The said accused person could not be apprehended as he fled before arrival of the raiding team. In order to unearth the racket behind such illegal activity, a true investigation is required by registering case under relevant section of IPC, for example, 120B, 411, 413, 414, 420, 421, 467, etc. My lord, my humble submission is that it is fact that I own that premises, but my lord, the way back in 2021, my lord, I rent that premises to one Moinul Haq, my lord, by executing an unregistered tenancy agreement, my lord. That is in page number 20. My lord, kindly peruse the page number 20, my lord. That is deed of tenancy agreement, my lord. That was executed on 1st day of March 2021, Baksa. And my lord, first term and condition, my lord, that this agreement shall be effect from 1/3/2021 to 28/2/2006 for a period of 5 years. And my lord, this agreement is for some junkyard business, my lord. I give that property on rent to one Moinul Ali, my lord. Now I am not at all aware of the deeds, my lord, which have been committed by the Moinul Ali. But police aggressively, my lord, suspected me that I have committed all this offence, my lord. And I am a resident of a place.
Moinul Ali's name is not FIR.
No, not in FIR, my lord. Not in FIR.
He is indulged in those kinds of business.
Not FIR, my lord, because I am owner of that premise, my lord. But I give in rent to one Moinul Haq by executing this unregistered tenancy agreement, my lord. And I reside in a place which is at least 10 kilometers away from the place of occurrence, my lord. That is Seknibari. And I resided on Dolong Park, which is mentioned in the FIR, my lord, clearly, that I am a resident of Dolong Park. But place of occurrence is Seknibari, which is at least 8 to 10 kilometers away from my residence, my lord. I am not at all involved, my lord. It is fact that I am owner, but premises is given and rent to one Moinul Haq, my lord. Whatever is done on that premises, my lord, that is responsible Moinul Haq, my lord, not me, my lord. I am not aware of. So, my lord.
The agreement itself is, my lord, it cannot be for a 5 years, my lord, tenancy agreement.
Yes, my lord. These are true, my lord.
Because
so, unregistered,
my lord, cannot be for 5 years, my lord.
Okay.
My lord, I may be protected, my lord, at this moment. My lord,
It's very.
my lord, apparently, my lord, I am not.
You may be innocent, but in nature of case.
Yes.
What kind of case?
My lord, other offences, my lord, are below all are 3 years punishment, my lord.
20.
My lord, kindly consider offences are 3 years punishment only, my lord. These 379, 420 are not at all attractive, my lord.
Yes. You're doing in your premises itself. Selling all those things in the name
That is
of
10 years, 10 kilometers away from my residence, my lord. 10 kilometers away, my lord. I given rent, my lord.
To 15 to 20 minutes to come from your site.
Yes, ma'am.
There in the
But-
premises. What is it?
My lord, at this moment, my lord, if some materials comes in the case, there, my lord, that may be vacated, my lord.
Yes.
20.
May I please, your honor? May not be 23, my lord. After 23.
After 20.
27.
27.
My lord, at 20.
May not be there.
26.
26. 26. Oblige, my lord.
Also, this is an application under section 437(8) of the CRPC, my lord, in connection with my lord. Number TPS case number 147. This has been registered under section 447, 467, 468, 471, 506. My lord, allegation your lordship may kind of see in the affair brought by the initial one, my lord, page 11, my lord. This is a translated copy, my lord. Here in this case, my lord, allegation has been made that a sale deed was executed in the name of the husband of the informant who had died prior to execution of the sale deed, my lord. This is the allegation, my lord. Prior to execution of the sale deed, the executant had died.
After that, yes.
This is the allegation, entire allegation, my lord. And my lord, this deed was executed in the year 2018, my lord. And she has found that the purchaser had taken over possession of the land, my lord, only in the month of May 2023 by collecting building materials. It attempted to raise construction over the same, my lord.
Then, my lord, this FIR was filed, and my lord, simultaneously, your lordship may cannot see in Section 2, page 16. One civil suit has also been filed, challenging legality and validity of the said sale deed. This is also pending till date, my lord. Now, my lord, the allegation is this: the petitioner, being advocate clerk, he stood as witness number 2 in the sale deed, my lord. He had only signed the deed as witness number 1 on being identified by his advocate, my lord. But in this case, my lord, your lordship may cannot see Annexure 5. Annexure 5, my lord. The main beneficiary of the sale deed has already been granted bail, my lord. Who is the page, my lord, 43, Annexure 5. Who is the purchaser of the LA sale deed? He has been granted bail. Page 43,
Annexure 5, my lord.
43. This Devnath Sharma was the purchaser of the sale deed, my lord. Next, your lordship may cannot see page 47. Deputy Sub Registrar has also been granted bail by your lordship. Page 46, my lord. Even, my lord, the advocate who had identified the sale deed, my lord, he has also been granted the privilege of Section 438 CRPC. Your lordship may cannot see page 49. In the LA sale deed, my lord, the Shailendra Kumar Sharma had identified the same, my lord.
So your petitioner is an advocate.
A clerk, my lord.
Advocate.
I'm clerk, my lord. And I only signed the deed, my lord, as witness number 1, my lord. Further, your lordship cannot see in Annexure 4, some medical emergencies has arisen in my family, my lord. In Annexure 4, my lord. Page 40, your lordship cannot see. On 20th June, my lord, my wife had given birth of a male child, my lord. Some medical emergencies has arisen, my lord, in the family. My presence in the residence is necessary, my lord. I am ready to cooperate with the investigating authority, my lord, to disclose whatever I have done, my lord. And what stake, my lord, I have signed the deed, my lord.
The bail orders that were shown, they are regular bail application, not anticipated bail.
Well, page 49,
page 43 and page 47, because the main beneficiary and also the sub-registrar, he was given bail after the detention period, after they were arrested. So
but, my lord, page 49 is a previous bail, my lord.
We cannot say, how he will be involved, because in some cases we have found, that the attesting authority and even the advocates were also involved, but we cannot say now,
Lordship, I cannot see page 49, my lord. Page 49, my lord, this is the advocate who has identified the parties to the deed, my lord. He has been granted privilege of 438, my lord. Page 49, my lord.
Parties to the deed.
He has identified as advocate to the parties to the suit, parties to the deed, my lord. Because identification is required, my lord, for registration of a deed. He is identified. I am ready to cooperate with the investigating authority, my lord. Let the case be come up before your lordship. If anything is found contrary, then I may be put behind the bar, my lord.
sir, the perusal of case diary and it was AB.
Yes. After perusal of the case diary. So then my submissions may be recorded. Yes. And the first week of August?
First week of August. 6 days.
I-
You're in India.
Only 7 days, my lord, I will appear before it.
Yes, they're conditioned about the other.
But
But it is a petition under Article 226 seeking quashing of the FIR.
Indian state government advocate will appear, my lord.
Yes, government advocate.
Lordship,
Still, we're trying to inform the government advocate.
Deep Cup. Oh, Deep Cup.
Yes.
My lord, in this case, my lord, day before yesterday, my lord, Lord directed to my lord obtain instruction whether case has been registered or not, my lord. So, my lord, today, my lord, morning, we have been informed by the police station, my lord, that case has been filed, my lord, but it is not registered. And this person, accused person, he has been, my lord, asked to, my lord, appear before the IO, my lord, to for some preliminary, my lord, investigation, my lord. That I have been informed, my lord. FIR has been filed, but it is not registered, my lord. And this person was asked to appear, my lord, in the police station because, my lord, they want to do some preliminary investigation, my lord, before registering the case. That is the, my lord, update till today morning, my lord.
My lord, my restitution case is on 28/6, next date for service. I have also filed a restitution case against my wife, since I have already been narrated on the other day that how I am being treated now from her family side. But still, I want to have my conjugal life back with her. I am doing everything. So at this moment, any adverse or coercive action against me from the police will derail the entire settlement which I want to undergo with my wife through this restitution of conjugal life. Let her come and let her appear before the family court, and then we'll amicably settle any differences if there is any. But at this moment, if any course of action taken from the police station, All Women's Police Station, will derail the process. Since I have also filed one FIR before the Ajahar, before the Mukalma Police Station, and they have also not registered. It is now, since completely a matrimonial dispute, my lord. So let us act in a common manner and let us try to sort it out between the husband and wife. Since restitution is there, 28/6, the next date is on 28/6, that is 2 days after 2 days. So any course of action from the police will derail the process, because I am also trying to make sure that she comes back to my life. I have nothing against her, but there is some allegations that one has come into her life, and I am going to sort that out also. Only thing is that she should come back. And if anything coercive action is now taken against me, then it will become very difficult for me. So no coercive action in this regarding this particular matter.
But it should appear for the police station.
Yes, I'm absolutely ready to cooperate. And
Received the notice now.
no, they have not yet given me any notice, but it is going to be filed, and it assumes that since Honorable Court is going to be on vacation, very assume the role of police is very much doubted. It is a bit doubted now because they are waiting. They have already she has filed the this one, the Azahar. The police is waiting so to take some course of action. So now thing is that on 28/6 the family court already the next date is there for restitution case. So at least no course of action against me at this point of time in relation to any case that will be registered, if any so. Since they have already also, the prosecution has come to know, and it is already, I am apprehending that police will be calling me up very soon. So at least some protection.
How can you get back that?
My lord, let him appear before the my lord, police station. Lord.
Absolutely. I'm
My
ready.
lord, since the case has been not registered, Lord, if some direction may be issued, my lord, otherwise. Otherwise, my lord, the case has not been issued. That is why I would say probably 41 and notice also not issued,
Yes.
my lord. Otherwise, my lord, they would have definitely issued if the punishment is below 7 years, my lord. We do not know, my lord, what is the ingredients of the FIR, but we have been informed that FIR has been filed, but it is not registered. And to do some, my lord, preliminary investigation, this person was actually appeared in the police. That's what we have been informed.
Fine. Right. My wife was all government products for all that one part of, but it's not that are the one right about and about the report. It is effectively adapted by the either be I have given some protection for and it's all going that I appear for the all of it.
And he will, my lord, he will cooperate with
Yes,
the
yes, definitely. As and when required and as and when called. Obliged.
That application is disposed of.
My lord.
Here PP will appear.
Lordship, what has happened? This is basically 482. We have filed under 226
Then we cannot appear, my lord. If it is a criminal petition, then we can appear, my lord.
because only PP made a party here for state of Assam. Therefore, GA Assam is not made a party.
The government is not a party because they have to at least make party now because a petition.
No, basically it's a quashing petition under 482.
Only PP made only state.
Writ petition also we cannot appear, my lord. Only, my lord, in criminal petition. If it is a quashing petition also, my lord. If it is a criminal petition, then we can appear. But in writ petition, my lord, we cannot appear.
Because it's a
Writ, my lord.
So may I submit?
Mr. Fukon will appear or who will
But,
appear?
no matter we government will at least notice may go in the meantime.
Well, generally what happens, if they file a writ petitions criminal, then the Home and Political Department made to be a party in this case. Because in 226, though it's written as a, my lord, the read 482, but the he made a party, my lord, to the Home and Political Department also, my lord, in this case. But only state of Assam represented by public prosecutor there. And the second respondent is the victim. And I am very much surprised, my lord, how victim, my lord, the minor girl can file FIR, my lord.
Lordship, minor girl has filed FIR here.
That is also
Now, and we are not the accused. We are the mother and brother and sister-in-law of the accused. The accused is in jail. Basically, in the FIR.
So what to do?
Now, Lordship, what has happened?
We are not the party also.
Lordship, what has happened generally? Habeas corpus petitions are petition criminal. Their state of Assam is a party. Here we have filed a quashing application under 482 to enlarge the scope on.
It is registered as a WP criminal law.
Yes.
Because it is
Yes.
If he filed, my lord, 482, read section 227, then his thing is different, my lord.
different. Then in that case, they are
Let he amend the petitions, my lord, direct.
otherwise.
No, Lordship, what can be done? Lordship, for the time being, Lordship would hear it and call for a status report of the. In the meantime, we'll file an impeachment application making government a party. Because the PP ultimately my senior have to answer in this because it's an FIR, quashing of an FIR basically. Lordship would see the prayer.
Lordship may do one thing. At this stage, notice may go. And in meantime, directed him to file and the impeachment of the parties, my lord, the respondent who was not available in this petition. Or, my lord, the direction may be given to file a fresh petitions, my lord, within liberty, my lord.
In that case, that should be video.
My lord, yeah.
Otherwise, unnecessarily take it both. Now, notice to whom? There is a fee here. And one victim is we have made a party only.
Yeah. And he also made party, my lord, victim's father and mother. Can respond number 2 cannot accept the, my lord, the court notice, my lord. She is minor. How can you be expected? So victim's mother and father made a party in
Matter
the.
is a bit, I mean,
What can be done? We will withdraw this and file application under 482 only. Thereafter, we can make a mention tomorrow.
And it's a mandatory provision.
Tomorrow.
Because Lordship, we are apprehending arrest. That's the.
In the vacation before the vacation time.
And in POXO cases, my mandatory to notice may go to the
Yes, obviously.
respondent. So let him, my lord, the liberty to file an afresh and appropriate petitions, my lord. তুমি চাইন তুমি হেৰি পঠিয়াব নোৱাৰিবা ন
ঠিক আছে
পাৰ্টি বনাই দিয়া
কিন্তু ইনফৰমেণ্ট
Minor victim.
Yes, that's right. How he can see
normally someone major would file an FIR. Here the minor has filed an FIR.
That was accepted.
And that was accepted and divorce of the procedure of section 19 of POSCO Act. Normally if 19(2) follow, now it is divorce. That in that case also the FIR goes.
Okay, we're giving you a liberty to file a fresh. I don't know if may come tomorrow, may not come. I don't know because either in other words you may make a mention for the vacation bench also. But tomorrow and after tomorrow
Vacation bench is also there, but they will try. They have to try.
Okay, then we will try both of the matter with the liberty.
Deeply obliged.
Much obliged.
Deeply.
Deeply. Much obliged.
What should be practiced?
Nanak.
Damay katwa daw ito. Ida. Mr. Judge. Damay katwa.
After vacation.
After vacation, I did it. Busy.
Your Honor, kindly pass over the matter for the day. It may be listed immediately after vacation.
After vacation?
Yes.
Otherwise, that's the...
I'm for the respondent not.
Huh?
I'm for the respondent not.
Want it fixed? You want any fix it?
Your Honor.
No, what is it? 25 steps.
Must have been your life.
May I please your lordship, my lord? Your lordship, kindly peruse the last order, my lord. There is a, my lord, typographical mistake on my first part, my lord. My lord, first part of cost title, my lord. It should be, my lord, 1/2023. But in the second page, my lord, you lordship, kindly go to the petition, my lord, of my bail application. Page number 2. Have you also got it, man? Yes. Here I done NDPS case number 324/2022. Other my lord, correct, my lord. And my lord, NCB case number also wrongly mentioned, my lord. Then, my lord, what happened?
There should be NDPS case number 324 of 2021.
No, my lord. You will also come to the next page, my lord. It was corrected, I write it correctly, my lord, but due to my lord, cut press in the my lord computer database, I file an additional affidavit, my lord. Your lordship, kindly come to the my lord, page number 1. Page number 81, my lord. That is X. It was right down as X, my lord.
So by this additional affidavit, you go.
Yes, my lord. Your lordship, kindly come to
the
the
correction. Or
your lordship, come to the para 4, page 4. Have you also got it, my lord? I have write down the cost title correctly.
para 4, page 4.
Para 4 page given number, page number to diya na. Lordship, kindly come additional affidavit para 4, inner page 4. X, that X.
পেজ নম্বরটা তো না লেখা হ্যাঁ
Page 4.
Yes, my lord. In the method, page 2 should be, my lord, substituted by this paragraph. To that effect, last time, my lord, also you kindly go to the order, my lord. It was right down, my lord. Only thing, order dated, my last order, my lord, 12/6/2024, my lord.
What is your correct?
Yes, my correct is that, my lord. NDPS case number 1/2023 under section 8C with 20B2C 29 NDPS NCB crime case number 19/2022. My humble submission, because only simple thing is that, my lord, easily I submit, my lord. LCR of NDPS case number 1/2023 may be called for. Earlier wrongly called 324, my lord.
That means in page number 23 it was incorrect.
Yes, ma'am. NDPS case number 1/2023. That LCR call.
It is written as NDPS case number 320 of 2024.
Yes, my lord.
It should be 1/2023.
2023, my lord.
And that apart, the NCB corresponding NCB case number is you have written as 18.
Yes, ma'am. NCB crime case number, my lord, 19/2020.
It should be 19/2020.
2020, my lord. Yes, my lord. And matter has already seen some, my lord, 19/7. LCR may be called for on that day, my lord, matter is that. Kan pipe malu tu harga ada kodu keluar.
And get this number for the option to be one of it and the prime get number and so it will be 19 of the prime in person order dated 12/6/2024. He has already filed an affidavit regarding the number of case number of entity as well as prime and then for the according to the so now we have to call for the NDPS 1.
1/2020.
The record has to be called.
Yes, my lord. Pending before the, my lord, additional district and session just number 5. I'm NDPS of Kabur Metro Guwahati.
District is the director. Call for and for the LCF and is the LCF of the LCF mark registered other small Roman of capital C and 29 prime number 9 which is spending report that at the end this number 5 come and this 4 come yeah basically
Raise the, my LCR.
so he wants to fix it after picking.
That ILF is 19/7. 19/7, man.
Earlier it was fixed on 19th.
So 19/7, 12/6 last line. List on 19/7. I mentioned it, my lord.
Why it has come.
I mentioned it because I felt it there. Only thing LCR, correct LCR may be covered.
Material. The matter pertains to Portfolio Lordship. As per my information, service was completed, Lordship. Let the instruction be.
I'll take the instruction, my lord. Let it be after 2 p.m. Man.
At 2
From whom is
From the office of the
From
public.
the office of the my lord, from our office, my lord. Notices were sent, my lord. But it is not clear in the whether they have issued through our office or not, my lord.
We have taken a step.
It was sent to the registry, my lord. After that, whether he has sent or not, I have to verify, my lord.
On last occasion, I have intimated from the office that the notice was served. Let the instruction.
Yes, second half, my lord.
I'll let it.
last petition of the defendant?
Yes, my succeeded case. That is why they are not preparing.
It is already done.
Yes, ma'am.
Nothing.
Case number lawsuit 77/24 dated 16/5/24. And dispose.
Lordship, in this case, Lordship, I am behind the bar, plus 30 days, Lordship, till date, Lordship.
Pass over the matter for time being, Lord.
Time be a bit difficult because the reporter are being here only for 1 hour because by 3 p.m. I have tried the schedule of interview with actually we are taking some interview from the grade 2 judicial officer of Bonnet. That's why they not permit this time. So the other matters also. So you are behind the bar since that
330 days, Lordship.
330 days. Can you tell us the stage of the case that
Yes, Lordship.
or if Mr. Kyle is appealing also?
Yes, Lordship.
You may feel that but let us see because there are some methods also otherwise or
Good, Lordship.
I look definitely now at
Lift your leg. Same prayer.
they're all NCP men. Definitely take them. Your petitioner is behind the bar.
My lord, for last 2 years and 10 months, I am behind the bar, my lord. And in fact, my lord, prime accused has also been granted bail by this honorable High Court, my lord. So, lord, your lordship may consider, my lord.
Consider how much they
Lord.
submit first. I don't know if time permits because one.
Because, my lord, the prime accused, my lord, he was granted.
Oh, I don't know. Because time is very short. Can it be mentioned before the vacation time?
My lord, lordship, I'd like to place the judgment of Supreme Court, my lord.
Judgment is all right.
No, my lord, what it says, my lord, when my
it's
lord.
okay. Judgment is all right.
My lord, it is regarding listing, my lord. That's why, my lord.
Regarding?
Listing, my lord. My lord, Supreme Court says, my lord, it passed a specific direction, my lord. When, my lord, the bail is granted by a bench of the particular High Court, my lord, then, my lord, in relation to the same FIR, my lord, all subsequent bail application has to be
It was
placed
passed by this court only.
by the Supreme Court, lordship. Not
No,
to
no, no, no. You have said one bail.
No, but by coordinate bench, lord.
The coordinate has done, not by this court.
Lordship. So matter may be placed before that bench. That's the besides the direction by the Honorable Supreme Court, my lord. Lord, we see-
all right, I know. So, who is who was the, I mean, in
My Lord, the bail order granted by the coordinate bench is at page, my Lord, 107, my Lord.
107.
My Lord. And it was only on the ground of, my Lord, delay in the proceeding, my Lord. Out of 13 witnesses, only 2 has been examined, my Lord, as of now. It says that fundamental rights.
Can it be listed? But these things, other branches are also overburdened.
As per the decision matter, if they
Has to be before the appropriate bench.
My Lord, let it be listed day after tomorrow before the appropriate bench. My Lord. Deeply obliged.
Deeply
My Lord,
obliged.
on day after tomorrow. Deeply obliged.
Deeply obliged.
Item 33, Lordship.
আমাৰ ৰেকৰ্ড নাই যদি আছে যদি শেষ কৰি দিম তেতিয়া নে কি
নাই তাৰমানে
Yes, conviction record. We have to pray before I am for interim bail from the court below 1 month, and you will be exhausted. That's why I pray that it may be taken up today.
See,
How
because I'm rising by 3.
I heard that you may rise up. I think.
I by 3.
Yes, that's true. That's why you may not be able to exhaust the entire list.
If conviction term was for
3 years. That's why there is a bail. He is on bail from the court below.
yes, from a
Item 19.
19 minor.
I am already on bail by the court below. Because conviction is 3 years with fine.
2-3 matters are there at 2, fixed at 2, na?
Marjana. For 3 years under section 418 and C.
418 and C.
My lord.
18 and
And
C.
2000, my lord.
Oh.
Take currency position.
It was not actually found in my position, my lord.
Have you annexed the order whereby he was, granted on interim way?
That is whether he is in
interim
previous bail. Previous bail.
Previous bail? Is there
I have not annexed it, my lord, but I made a statement that I was granted
They
bail.
will not do. Have you annexed any order, that kind of order? Where apart from it can be seen that he was
My lord,
still under.
court below has released me on bail, with the direction that I may statutory period is 1 month to prepare an appeal here. So within 1 month I have come before your lordship. Under 389 I am subject to get the bail. That's the court also.
I order was passed, no? Which day?
Yes, my lord.
6.
Convicted accused Nilakshi Rishi is informed about his right to appeal against the judgment, order of conviction, sentence, either by appointing his own advocate or through legal aid. It has been mentioned for page 43 of the judgment.
48, paragraph 48, my lord, page 42, my lord.
43.
42, my lord, page. 48, paragraph.
Paragraph 48, yeah.
48, my lord.
Issue sentence warrant against the sent the convict accused to revert to jail to serve the sentence. Yeah, nothing it will be there.
But not mentioned, my lord, whether he is...
Well, it is obligatory. It is a statutory provision of law, CRPC. Please, it is going to be end by next week.
For 1 month, did I? We are praying for extending of the previous bail or
Previous bail.
Your Lordship, you are allowed to remain on previous bail.
So is there any order you have annexed? Yes, of course.
No, it is not there.
Then till this way, so you are.
No, Your Lordship, it should be the fresh bail also. I have got no objection.
Otherwise, in regards to admission of the evidence,
Admitted, call for the record.
Call for the records and
it will be again for admission follow-up or it can be admitted.
Admitted.
admitted. It is statutory appeal, madam. It will be admitted.
Criminal appeal.
Call for the record.
Criminal appeal. One is criminal appeal, one is criminal appeal. This document. And I had if the defendant suspected the report but not put the fact in the case of particular alright what I and that what that the bill was passed on court. And they brought get the down for the person is from which district? The person is from Borpeta Road.
Yes.
Permanent resident, permanent.
Yes, Padma.
After
But I is disposed of it.
In the notice will go also. In the main case, notice will.
And what amount your Lordship given? How much?
20,000 with 150 to the satisfaction of the session.
To the satisfaction of the trial court.
Yes. Trial court.
The session.
Session court.
Yes, the additional session judge.
And you honestly compare to protect
Sure.
after going. It is. I guess
Wait.
was picture 2.
A matter. A reporter from the Office of the Public Prosecutor regarding the service of money.
After control.
Yes.
In this case, Lordship, and I submitted Lordship 330 days I'm behind the bar, Lordship. And this case, Lordship, already the co-accused Lordship, he submits in the statement of 67, Lordship, that there is no any roll-up from my side, Lordship. Lordship, on page number, Lordship, page number 18, Lordship. On page number 18, Lordship, paragraph number 18, Lordship. May I have read, Lordship?
Yes.
That the voluntary statement under section reason this of the NDPS Sec 1995 was recorded by the Sek Hoping with the co-accused, Lordship. In this voluntary statement, Sek Hoping stated that he is an unemployed person. He stated that he brought the seized heroin from one lady, namely Kikim. Residents of this, he brought it at a amount of rupees this per short case. He said that Miss Kikim rupees reasoned this in a case in advance and was supposed to pay the remaining amount after the selling the consignment. Sek Hopin was contacted one of his acquaintances, namely Choba, who lives in Lilong, Tawbal district, and who Sekum Hopkins was new to be dealing in drugs trade, and Sekum Hopkins him, Choba, whether he knew anyone willing to buy heroin. Choba then told him he knows in persons is willing to buy the heroin from as long as he's delivered the same to him at Guwahati. Choba also told to co-accused Lordship, that is Sek Hopin, that Shahrukh Khan will be buy the heroin at a rate of rupees this and this per shop cases. Choba then given the mobile number of the Shahrukh Khan to Sek Hopin for deliver. Choba also given the another mobile number of an other person who was the brother of the Choba, and Choba was told to Sek Hopin, and Choba brother will liaise with the Choba for final delivery. Then Sek Hopin contacted Shahrukh Khan through the number given to him by Choba, and they agreed for that as per the dealing. Sek Hopin will bring the heroin to Guwahati from Sekola, will collect the same and make the payment in cash. As such, Choba and Sek Hopin agreed for dealing. Sek Hopin will reach the Guwahati with Choba, will also come and will arrange the deliver. Then 31/7 this after considering of the 59 soft cases containing heroin in false cavities in a Maruti Suzuki bearing registration number this, and Sek Hopin comes to Guwahati along with Lordship. Now my name comes out along with Vijay Gupta, and they reached Guwahati to one evening this, and after reaching Guwahati, Sek Hopin gave a call to the Choba, but Choba informed the Sek Hopin that he had not reached Guwahati yet. The Choba told to Sek Hopin to collect with his brother for delivery. Sek Hopin also called to Shahrukh Khan, who also asked him to come to the Kokrajhar, but Sek Hopin told to Shahrukh Khan that it is too far, and that this was unwilling to proceed further, especially his Sek Hopin vehicle's conditions was not. Sek Hopin's vehicle's Lordship was not very good. Sek Hopin told the Shahrukh Khan that the delivery be made within Guwahati. Thereafter, Shahrukh Khan agreed and told to Sek Hopin to wait in Guwahati, and that Shahrukh Khan will come to pick up the consignment of heroin. The Sek Hopin, along with driver, booked a room at Lordship. The Sek Hopin, along with driver, that is Vijay Gupta, Lordship, booked a room at Goswami Lodge near downtown hospital, Guwahati, and they, Sek Hopin and the Vijay Gupta, were allotted room number 16. Sek Hopin, along with the Vijay Gupta, took out the, now my name engaged in this case, Lordship. Gupta took 59 of the case conceals in the Maruti Gypsy and kept the same at the wardrobe in their hotel room. But one course of the investigation, it is established that the accused Sek Hopin took name of Miss Kikim, the mobile number disclosed by her, this Lordship. Entire this statement, Lordship, nothing is my role, this comes out here, Lordship. He engaged one person, he was dealing in the drugs, Lordship. He again take the consignment, he fixed all the things, Lordship. Sek Hopin, this is not my statement, this is a statement of the co-accused of this main case, Lordship. Now, Lordship, I am coming to my statement in this case, Lordship. On Lordship, page number 21, Lordship. It is very clearly in my statement that, Lordship, I am a professional driver and I was taking a 10,000 rupees, but one line here mentioning that, Lordship. I am reading from this. In a Lordship, the voluntary statement was accorded to Vijay Gupta. Understand reason this. In his voluntary statement, Vijay Devnath was confessed. Vijay Gupta, Lordship, mistakenly written Vijay Devnath, was confessed. If the Vijay Gupta is a driver since 20 years, Vijay Gupta stated that he met one person, namely Sek Hopin, 1 month ago at Matripukri. At that time, Sek Hopin was told him he He is involved in illicit trafficking of the heroin, and Sheikh Hoping was also asked to Vijay Gupta if he carry heroin drugs with him by Vijay Gupta's vehicle. This is not a Vijay Gupta vehicle. We got in the statement, Lordship. Vijay Gupta's will pay rupees 10,000. On his proposal, Vijay Gupta was agreed and traveling for the monetary benefit. On dated reason this, Sheikh Hopkins called to the Vijay Gupta on his mobile number this and told to the Vijay Gupta to come to his house at Damdai, and also told the Vijay Gupta to go to Guwahati with Sheikh Hopkins with heroin concealed in false cavity in the Maruti Gypsy reason. They bought Sheikh Hopkins a lap for Guwahati at about this hour on 31/7/2023 from Sheikh Hopkins house at Damdai. And reached at Dimapur, Nagaland, and at about and stayed at hotel Galaxy at Dimapur town for night. On dated this, a lap for Guwahati from Dimapur, Nagaland, and they are reached at Goswami Lodge, Guwahati at 16:18, and Sheikh Hopkins along with Vijay Gupta was booked a room number 16. This all the Lordship. Here, Lordship, only one thing comes out, Lordship. He booked me as a driver, and the car belongs to that person, Lordship. But in this very clearly comes out that, Lordship, I never having anything related to in my past life also there, Lordship. I went there only having an amount of rupees 10,000. He booked me as a driver. In this case, Lordship. And Lordship is on page number, Lordship. On page number 18, it clearly comes out that, Lordship. On page number 13, Lordship. On page number 13, Lordship, the below part, Lordship. In paragraph number 9, Lordship. In paragraph number 9, the below part, Lordship, on asking about the documents, they stated that the Maruti Gypsy belongs to his relative, namely Kisi Hokip. That the car also there, Lordship. He only booked me as a driver to come to Guwahati, Lordship. Or here one thing is that, Lordship, when a person, Lordship, when a driver went with one owner, Lordship, in any hotel, Lordship, that the hotel department thinks that, Lordship, they will give a personal room to the driver. No need to book the room for the driver also there, Lordship. Here the room was booked on the name of the co-accused, Lordship. In this case, Lordship, co-accused. And the things recovered from him also, Lordship, and an entire, Lordship, for purchasing and to selling and to do contact, Lordship, all things the co-accused done in this case, Lordship. My submission is that I am simply a driver in this case. 330 days I am behind the bar, Lordship. I never involved in such type of business in this case, Lordship. Never, Lordship. And co-accused disclose all these things, Lordship. And Lordship, I have a liabilities, Lordship, because fully family depend upon me, Lordship. On having a 10,000 rupees, Lordship, I only from Manipur to Guwahati, Lordship. I am not asking the more amount also there, Lordship. What things I deserve, Lordship, that things I ask, Lordship, 10,000, Lordship.
Lordship, in this case, final complaint has been filed on 25/1/2024. Then Lordship, charges came on 23/2/2024. Till then, Lordship, 25/1/2024. Charges came on 23/2/2024 against the petitioner, Lordship. Till now, Lordship, 2 witnesses have been examined. Witnesses are coming and they are duly examined. So next date is, Lordship, 9/7/2024 for evidence, Lordship. So Lordship, this is 9/7/2024 for evidence, Lordship.
There is a long list. Only 2 witnesses examined this case, Lordship.
This is the status, Lordship. The trial is at the initial stage, Lordship.
Lordship, my submission in that, Lordship.
And Lordship, contraband recovered from the possession of the petitioner and the other co-accused person. And Lordship, 0.673 kgs of heroin from the possession of recovered from the possession of the petitioner, Lordship. He was at the room, at the lodge, Lordship. Lordship, may kindly come to page number 35, Lordship. That is the role of the petitioner, Lordship. May I read, Lordship? Accused Vijay Gupta is the associate of carrier Saikhom Hauki, trafficking of 0.673 kg of heroin. Carrier Saikhom Hauki made plan with his associate and hired Maruti Gypsy bearing registration number so and so for trafficking of heroin. Vijay Gupta and Saikhom Hauki both are brought the consignment from Manipur to Guwahati for supply purpose. on the basis of voluntary statement recorded under Section 67 in NDPS Act 1985, it is clear that accused Vijay Gupta was consciously involved in the trafficking of the heroin for money, Lordship. Accused Vijay Gupta further disclosed in his voluntary statement that he will be paid by Sekhom Hawkip amount of rupees 10,000, Lordship. And fourth number point, Lordship, accused Vijay Gupta had disclosed his voluntary statement that they were communicated with their associates by telephonic communication between accused Vijay Gupta and Sekhom Hawkip carrier by telephonically. CDR analysis also clarified the involvement and the relation of accused Vijay Gupta with other accused person and suspect person in this criminal conspiracy. Vijay Gupta and Sekhom Hawkip involved in this trafficking, Lordship, and how contraband was recovered, Lordship, that is clearly mentioned in the Panchnama, that is here in page number 42, Lordship, third para, Lordship. He was inside the room, Lordship. Contraband recovered from the possession of the petitioner, Lordship. Page number 42, third para, may I read, Lordship? On asking, they introduced themselves as Sekhom Hawkip, Lep, so-and-so, Hawkip, Songkel Jojang, Junmol, so-and-so, and Vijay Gupta, the NCB, the Lordship, fourth number line, Lordship. The NCB team members and both the independent witness were also introduced to them. After that, they were also informed about the information available with the team regarding trafficking of heroin, and they were informed of the intention to conduct search of the room by the NCB team. Before initiating the search of the room, NCB team requested them to conduct the search of NCB team, and the two independent witnesses, to which both of them declined. On asking, they admitted that 59 soap cases containing heroin are kept and concealed inside wardrobe of room number 16 at Goswami Lodge. The team requested them to open the wardrobe. When Vijay Gupta opened the wardrobe, it is found that some soap cases are there in the last portion of the said wardrobe. On opening the recovered soap cases, they were found containing orange color granular powdery substance packed in transparent polythene. Next para, Lordship, all these aforesaid soap cases taken out from the wardrobe, and after counting, total number of soap cases were found to be 59. When opened, all soap cases, orange color substances packed in transparent polythene were found packed in each soap cases. A small quantity of safe substance were taken out from each of the 59 soap cases and tested separately with the help of the drug testing kit brought by the NCB team. All the tests gave positive result for heroin, Lord. So, Lordship, sufficient materials are available which proves that he is involved, the petitioner is involved. And it is my humble submission, Lordship, this trial is at the initial stage. So, this is my...
Lordship, my Lordship. Lordship, in this case, comes to worship my Lordship. Without having the thing that Lordship, yes, this is the fact, Lordship. As I read the voluntary statement, Lordship, 10,000 rupees is there. If I have any role or I have interest, Lordship, then I will ask the more amount in this Lordship. I am only asking the amount. What will my thing, Lordship? Only 10,000 rupees, Lordship, from Manipur to Lordship. And in this case, Lordship, in Syria also clear that, Lordship, anything should comes out, Lordship, I manage anything, Lordship. My entire thing is managed by the Lordship, co-accused, Lordship. He did a contact to that very person, those who sell the same, Lordship. He did a contact with that very person who will have to purchase the same, Lordship. My only having a role is that I give him company, Lordship. I'm saying that, Lordship. I'm giving him company, Lordship. I drive the car and came to the, and when the seizure list was done, Lordship, at that time I was also present in the room, Lordship, with having my honor, Lordship. And I am the person, Lordship, when the investigation department came to the room, Lordship, I show them, Lordship, here the things are there, Lordship, in the wardrobe, Lordship. Lordship, in this case, I do not have any role. In my past life also there, Lordship. I do not have any role. In the present time also, Lordship. Only thing is that, Lordship, if I have an interest, Lordship, Lordship, I will ask the monopoly amount from the Hakimas of the Lordship. And in the co-accused, Lordship, statement, co-accused, no anywhere, Lordship, co-accused stated that I am the person who helped him to doing this business. I am to help him to do a contact with him. Nothing any shit comes out in this case. Only having that, Lordship, I asked 10,000 rupees. I drive the car. I took him from here. I am already getting the punishment in this case, Lordship. 330 days, Lordship. I was never involved in this type of cases, Lordship. Now I regard, Lordship, by having a bad company, Lordship, how give me a punishment, Lordship. Lordship, my submission that, Lordship. In this case, long trial is there, Lordship. I am only asking a bail, Lordship, in this case, Lordship. I have a minor child. I am not having a person. I am giving my statement. 10 years, Lordship. I am doing it I am by professional driver, Lordship. But investigation department doing anything there, Lordship, in the 10 years, Lordship, whether I involved in any cases, Lordship. Whether any cognizable or non-cognizable cases in my life, Lordship. My thing is that, Lordship, I am in the behind the bar. Again, I met with just 3 persons, Lordship. Maybe I am not getting the bail. It will direct hamper my family also there, Lordship. Because I do not have any other source of income, Lordship. If I involve, Lordship, in my earlier life, in this type of cases, Lordship, then I make a good bank balance, Lordship. My submission is that, Lordship, long trial is there, Lordship. Allow me to go on, but in any condition, Lordship, I will appear, Lordship, fulfill the trial court, Lordship. I will submit, Lordship.
Deeply obliged.
A report was from the Banana.
Yes, Sami? Yes, madam. As per the report, madam, service is complete, madam. Service is complete, madam.
Let the amicus can be appointed, Lordships. There is a POCSO matter, Lordships. And fix the matter after the vacation, Lordships. P. Dr. Lordships.
Sorry?
P. Dr.
Oh, sorry, Peter. Part District Peter. It's up he is 2 or 1? 1. 2.
It is respond number 2.
Respond number 2.
That the however, appointment আপনারা Mr. S. Das, present the responsibility. Please keep an after
vacation.
After vacation and fix it on.
Fix it.
17.
Publish it.
May I please, Your Lordship? 33. I'm for 33, Lordship.
You are for 33?
Yes, Lordship.
And
I am for 47, Lordship.
47.
Yes, Lordship. Lordship, for 39 application.
B, both are B.
Both are B. Both are B.
Okay. Yes, 32 you can submit.
As on today, Lordship, 46 days, Lordship. Petitioner behind the bar, Lordship. 47 days, Lordship. FIR, Lordship, is page 47, Lordship. Sorry, 14. 1/4 page.
Yes, one book.
May I read?
What type of case?
Lordship.
This is registered under?
Bongaigaon PS case, long FIR, Lordship, relevant.
I mean, the contraband with intermediate quantity was recovered.
Yes.
LS to have
Intermediate quantity. That is, that part is stated in the page 15, Lordship. Page 15. Long FIR, I would like to read out just relevant. The recovered suspected heroin was weighed by me with the help of digital weighing machine belongs to Bongaigaon Police Station in presence of above mentioned witnesses, and the gross weight of the suspected heroin is found 37.56 grams along with container. The above mentioned recovered items were seized by me at 10:20 p.m. as per seizure memo in presence of the above mentioned 3 witnesses. The seized contraband of suspected heroin were packed and sealed by me in presence of above mentioned witnesses at the place of occurrence. And there is 18 numbers of container, and along with container, total 37.56 grams. Without container, it will be more reduced, Lordship. So as on today, 46 days, Lordship. I am praying for the well, Lordship, in any condition, you will cooperate with the trial. There is earlier there is no allegation such type of against him, and till then no cases pending also against him. He will appear before the trial commission every day.
So this 37 this gram.
47 of
Yes. 47, my lord.
No. Yes, 47.
May I please, Your Lordship? My Lord, I am in detention since 27 days as on today, Lordship. My Lord, contraband recovered is intermediate quantity, as my learned friend has said, Lordship. And Lordship, already major part of the investigation might be completed because already one of the accused is 47 days in custody, and FIR was lodged long back on 12/7. On 11/5 he was arrested, Lordship. So my Lord, investigation part may have completed in the meantime, and as we are in jail, so further custodial interrogation may not be required in this case, Lordship. Considering the length of detention, Lordship, I may be enlarged on value. We will cooperate with the investigation, local person, Lordship. Any condition may impose, and we have no past antecedent of any criminal record, Lordship. In that view, Lordship, we kindly consider.
My lord, this 37.56 gram, Lordship. That is, my lord,
Lordship, one more submission, Lordship, and the recovery was made from the item 33. Only from item 33 recovery, that is reflected in the FIR itself. Lordship, may kindly see page 11. Page 11, the relevant portion, Lordship. 3 lines I may be allowed to read out. I searched the body of Sharif Ali. Sharif Ali is item 33. In presence of above noted 2 witnesses under videography. During search, the NDPS items have been recovered from the possession of Sharif Ali from his right long pant pocket. 18 plastic vials loaded with suspected heroin, weaving in a black color polythene. With container, Lordship, 18 numbers of containers are there, and along with container, 36 gram, Lordship.
37. So I tried to find out from the case diary, my lord, what is the actual quantity, my lord. It is mentioned, my lord, 37.56, that is with container, my lord. Without container, it is not mentioned, but even in the inventory also, my lord. What will be the exact amount, my lord? Anyway, my lord, it will become intermediate quantity, my lord.
But the duty of the investigating agency to weigh the actual weight should be determined.
It should be there, my lord, but I have not found from the case
It may
diary.
come down to
Generally, it is if it's suppose small plastic container,
It
may
is
not
a
fall in such a manner.
plastic
Plastic container, definitely, or maybe it is up to 37.5
India,
grams.
it will come to
So, obviously, it will be intermediate, but it is not in a small quantity. I think.
I don't know. It will be
Plastic
more than.
container
Maybe little higher than small quantity.
That is not, my lord, clear from the case diary, my lord. Anyway, my lord, this contraband it is recovered from Saripali, lordship. Saripali it is recovered, my lord, and he has implicated this Mokshed Ali. But from Mokshed Ali, nothing has been recovered from the as implicated from the case diary. And it is pending for to collect the FSL report, my lord. It is not ready, my lord.
But how Mokshed Ali come into picture? Is it 47? 47 how come?
My lord.
Under
My lord, when the Saripali was arrested, my lord, then he was interrogated. He has implicated Saripali. He said that I procured from Saripali. I used to purchase from Saripali. Sorry, I used to purchase from Mokshed Ali, lord.
Yes, obviously for Mokshed Ali, probably from position of Mokshed nothing to them. It was not recovered anything. But the question is there any evidence in the record that Mokshed Ali used to sell all these things to someone else?
His statement, my lord, he has denied, my lord. In Mokshed Ali's statement, my lord, he has denied. He has stated, I never supplied any, my lord, contraband to my lord Saripali.
But for the other
But
witnesses?
Saripali, other witnesses, my lord, they are seized, my lord. They are seized. Only, my lord, on the basis of this Saripali, lord, he was arrested, my lord.
And why Suripali may implicate me, I have stated in paragraph 5, Lordship, of my petition. Anyway, Lordship, on the length of detention, it is not too, recovery is also not too high, Lordship. With 18 numbers of plastic container, 36 gram. It may go little higher than the small quantity.
By betting as a drug peddler, you will affect the entire society, the young generation.
Any
small quantity, big quantity,
Yes, Lordship,
whatever,
that's true.
but
That's
you are
true.
going to destroy the young.
Crime goes against society, Lordship. That's true, Lordship.
Why you are doing this?
Yes, Lordship.
Why you are doing
There is Lordship, they are not actually a peddler. Then maybe they are consumer.
18 numbers of
Sometimes used to consume, but
18
not
numbers
peddler.
of packets you took yourself, I mean, in your pocket, only to consume all these things. So you are very, I mean, rich person, I think.
No, they are peddler, my lord.
Definitely.
It is, my lord, they are peddler.
Otherwise, you have to be a very rich person.
For self-consumption, lordship, they will not carry in 18 different packets, lordship. For personal consumption,
any
personal-
condition.
Any condition.
Any condition
What
may.
is the other aspect? What do you want to say? What do you want to study?
Regarding my FSL report is pending, my lord. Otherwise, investigation sufficiently progress, my lord. What I have gone to the case diary, my lord. It is
So
sufficiently
can it
progress, but
fix other date or within?
my lord, we can fix it after vacation, my lord. But this person, my lord, that 47 days is it will.
No, Lordship.
It will complete more than 60 days, my lord. 60 days, my lord. If we fix it after reopening, my lord.
During vacation code, 11.
So vacation code we cannot fix. So then we have to take permission from the state.
No, but is there any such kind of report from the IO that matter is substantially progress and the
My lord, that is not there, my lord. That is the last, my lord.
Last entry
Last
is?
update is, my lord, on 31/5, my lord.
thereafter there is
Thereafter,
no
no.
Local person, Lordship, may impose any condition
After
Lordship,
arresting
will
the
abide by.
second accused person, Mokshed Ali, my lord. That is no other entry in the case.
एक आ जाता
the IO as per the FIR, the 18 numbers of that 37.56 gram of heroin was suspected heroin was police that we detected considered, but those suspected contraband was under was it called and he moved for in peddling of the he's not a drug peddler and not for the of more so just criminal other criminal activity not other areas of this it what is the that if the activity is not progress and further considered however it important it important assessment is appropriate. Mr. Porter regarding that the copy FIR no examined by the till date and from the note of charge that the report it has already been sent for on expert subject, but on expert subject, there is no note on adequate subject. Sharply. He is from your
Special Judge Bongaigaon.
Huh?
Bongaigaon.
No, Bongaigaon. He is from which district?
Which resident of place?
Bongaigaon.
Village Daukizar, PS Bongaigaon, district Bongaigaon.
Now come 40.
Am I Hussein?
No pain was decided. Wait, but from he never that kind of business and was by he is on it is and I hope for time. But that from that from this and exam so far I know it for except Okay, you are granted.
Highly obliged, Lordship.
Lordship, I have not heard properly whether allowed or not.
Allowed.
Allowed.
Obliged.
One more item. Before starting it, I just want to ask you, which is the case of what nature of case? POCSO. Within 10 minutes, if it can be.
Search it submitted.
That is already been submitted. Since when you are in custody?
38 days. 38 days.
38 days.
Arrested on 19/5/2024.
Arrested on 19/5.
Yes, Lordship.
You are Mr.
M.U.E. Bhuya.
M.U.E. Bhuya. That of is posted for design. But it's submitted by Mr. Board. It has already been charged.
Charge sheet number
Right.
109/2024, dated 25/5/2024.
So you have to approach for the London Trial Court with the appropriate application. So, the petitioner is ever that could be that could be London Trial Court with an appropriate copy. Oh. Goes after here.
My lord, in this case, my lord, FIR, my lord, this my lord, incident was, my lord, 1 month ago, my lord, 4th March, 79 days, your lordship.
Oh, that's right.
79 days already behind the bar.
Okay.
And age is mentioned in the, my lord, local vernacular, that is, my lord, page 12, 22 years. Yes, my lord.
The victim is 22 years.
22 years in the Azahar, my lord. In the bottom also it is mentioned. Yes, ma'am.
Now, what was the instruction?
My lord,
I mean,
yesterday, my lord, yesterday,
what reason why it is declared?
Yesterday, my lord, he appeared for the informant notice after receiving notice.
Yes.
So he took time, my lord.
Oh, achha.
He took time yesterday, my lord.
Okay. Otherwise, as per his submission, our case is this.
79 days already he has learned the lesson.
Yes, 79 days. What which section is this?
What's it?
Under which section case is registered?
Yes, my lord. 365 and 366A, my lord.
Section 4.
Oh, yeah, POCSO section 4, my lord.
What are there?
Subsequently added.
366A, 376, 4, then 4 is also added.
Yes, my lord.
4 POCSO is also added.
Yes, ma'am.
So on what basis you are saying that she was the major?
It is mentioned in the FIR.
It's not Paraboso, it's Paisboso. It's not Paisboso, it's Paraboso.
Paraboso, my lord.
It's only 12 years, no?
Her date of birth has been changed, my lord, and as per her date of birth, her age is date of birth is 9/7/2011, my lord.
Yeah.
No, I have annexed here.
22 years.
Lordship, I have
You may
annexed.
annex, but it is the FIR, it was
Yes.
12-year-old child, not 20.
Yes, my lord.
Why are you saying she is major?
FIR is wrong. It is mentioned.
This is the birth certificate.
But yes, obviously, FIR is 22 years.
Yes.
Obviously. Why? Why 22 years?
In bottom also mentioned. 2
In
times
bottom.
mentioned.
Okay.
2 times 22 years.
Yes, 22 years. Yes, 22 years.
But other things.
FIR was written by somebody else. The informant only put her thumb, Lord. He did not know what was written. As per her husband was written, but what age was written, that was not her information.
It was not within her knowledge.
This is the birth certificate of the card. I have heard.
No,
In
that
164
is also seized
Yes.
by police.
Yes, my lord. In 164 also, my lord, 13 years. My lord.
Yeah, FIR lodged up 1 month thereafter, my lord, incident. Because, my lord, incident as it is stated, my lord, 8/2 to 24 and lodged Ezahar 4th March 24.
Let's say 8.
Date of 8 of February, my lord, incident was. And Ezahar lodged on 4th March.
Near about after 1 month.
Yes, my lord.
9/7/2011 is the date of birth, my lord, as per the preserver. And in the 164 also she has implicated, my lord, that the other co-accused, my lord, whom she, my lord, says in the FIR, my lord, one Anisha, my lord, she urged her to go with her, and accordingly, my lord, she was introduced to this accused person, and after that, my lord, the things happened. Like there's in the 164 is clearly mentioned regarding that.
So what
And
stage of the case at present? But the charges is already filed now.
But in Ezahar it is mentioned, nobody only.
And that's her statement is also there, my lord. He also stated that on that day, my lord, they both of them went there and stayed there, my lord. It is there.
Regarding the sexual assault.
Yes, ma'am. But her statement is not regarding sexual assault, my lord. But she admit that they both went stayed together, my lord. My lord, may I just put a statement, my lord? This is from informant side, my lord.
So what is your plea? Why this case has been now taken?
Lordship?
What is your plea?
My plea is that, my lord, she, along with one friend, possibly, my lord, went there and meet this accused person, my lord. Thereafter, they went together to roam somewhere, my lord. And thereafter, my lord, this incident is alleged, my lord, here, according to me. And already 79 days he is behind the bar, my lord. He has learned the lesson and he will cooperate the investigation, my lord.
Yes.
First of all, the accused person confessed that. Kindly see the forwarding at page 14.
Page 14.
Yes.
Okay.
Ground of arrest, ground number 2. During interrogation, the arrested accused confessed he is guilty. Then, if the accused person is not number 4, if the accused person is not arrested, he might threaten the complainant as well as witnesses as the witnesses of the case. Thus, he may impart an investigation. If the accused person is an influential person, if he is released, then he may threaten the informant, her daughter, and this girl is 14 years old. If he can take the girl, kidnap a girl of that age, then he can kidnap other girls. So, 79 days. He should not be released. The total period is 90 days. Although he is under the bar for 79 days, but he does not complete that 90 days. So, no. And if he is not, perhaps the police may submit a circuit also. So, before 90 days, I humbly request the Honorable Court not to grant bail to that. Otherwise, the informant may be in trouble. There is some threat.
After vacation, it will be already 70.
It will be completed 90 days. So we have to dispose it either or.
Yes, because either we have lordship has to dispose it of,
Yeah.
or otherwise, my lord, because we cannot retain the CD, my lord.
Yes.
Because,
Retaining is one part, and that after,
yeah.
if he will cross 90 days, that
Yes,
is also one.
that part 90 days. But we have to then send back the CD, my lord. Or resubmitting.
Considering length of 79 days already, my lord. Only, my lord. Yes, yes, my lord. Only.
He is a very influential person. There is fair to the informant.
No, 11 days difference. Only 11 days, my lord.
Very powerful.
It's a very powerful. Mandal.
Yes, sir.
Hmm?
Well, really to him, he said 4 days. My friend is saying that they went for roaming somewhere. 4 days they were there. Oh.
In roaming, one cannot spend 4 days.
I mean, one of the witness name is there, Anisha Khatun. She was possibly introduced, but that is mentioned in page 10, my lord. So, my lord,
He is a man of. His age is
25 years. Accused is 25 years, my lord. And her friend is 18 years.
so I don't have time after the interview only pass the order. So
But considering the length of detention, 11 days difference only, my lord. Otherwise, after vacation, my lord, it will be in fact space, my lord. I have take this brief from
meeting the schedule.
yes, sir.
Only on 11 days, my lord.
So rest don't have any alternative. Some bill matters are also there, but it has to be accommodated with most probably most of the matters may be after vacation.
Item number 45, my lord. It has some urgency because.
No, I don't know. We don't have actually. When it can be fixed.
Item 20, my lord, on 28, my lord. Earlier it was.
See, she will.
The matter will become infected.
What to do?
Yeah.